Make a start, and yes, I have the button. Yep, we're live. Yes, have it done. Yep, it is on. Yep. Okay, just a brief overview in relation to today's meeting. The oral evidence with Judge Marion. Somebody hasn't muted, please. I don't know who that is.
Hold on a second.
It's quieter now. Right, thank you. We'll start again. We have an oral evidence session with Judge Desmond Marion on the recommendations, the findings and the report of his review of the hate crime legislation. Oral evidence session with the Northern Ireland Children's Commissioner and consideration of proposals for the call of evidence in relation to the Justice, Sexual Offences and Trafficking Victims Bill, and then written papers on SNI's annual performance and activity report, and that will give us the basis of our meeting today. Just to advise members that you're welcome to use the mobile devices as long as they are in airplane mode and all devices are muted. This includes members' tablet devices. They can connect to the Assembly Wi-Fi. Also to remind members that we are obliged to declare any financial or other relevant interests which may reasonably be thought by others to influence their approach to a matter under consideration. Any members who have interest to declare in relation to today's business should do so, or when the particular matter arises in the meeting. And if there's no declarations of interest, we'll proceed. Can we have agreement for the two oral evidence sessions to be reported by Hansard? Agreed?
Agreed.
Thank you. Apologies. There's apologies from Doug Beattie, Sinead Bradley and Emma Rogan. Peter Weir plans to be with us. He has another meeting, but he may be slightly late. Linda, Rachel and Robin and Gemma are joining us by Starleaf, and we welcome them to the meeting today. Emma has delegated her vote to the Deputy Chair, to Linda, under Standing Order 1156. Item 2, the draft minutes of the meeting held on the 1st of July 2021. They're at pages 5 to 16 of the meeting pack. Are you content that this is a true reflection of the proceedings of the meeting held on the 1st of July? Agreed? Okay. Item 3, matters arising. Correspondence from the Executive Office Committee regarding the Troubles Permanent Disablement Payment Scheme, and that's at page 18 of the meeting pack for that correspondence. The Committee for the Executive Office has written raising concerns regarding the awarding of the contract for the delivery of the Troubles Permanent Disablement Payment Scheme to Capita, given the recent report by the Public Services Ombudsman, which found systematic maladministration regarding the personal independence payments, for which Capita also has the contract. The Executive Office Committee has asked that the Justice Committee gives assurances that there is no repeat of the issues with the PIP process. The Committee agreed last week to request further information from the Minister of Justice regarding the appointment of Capita to deliver the scheme and the details of the procurement process. So this is really just to note the correspondence from the Committee of the Executive Office and give obviously any further information that we receive in regards to this matter, we can refer it back to the Executive Office. The further informal meeting with the Victims Representatives Group on the scheme was held yesterday, and along with Linda, Sinead, Gemma, Peter and Rachel, we attended. And I think members will agree that that was a useful exchange, and I think that there are a number of issues which have arisen out of that. They raised a number of issues of concern, and you'll find a paper outlining those on pages 4 to 6 of the table pack. And I think that out of that there was a number of things that we had probably thought would be useful to do. One was that we should request departmental officials and Capita to appear before the committee, and I think that we should in the light of the ongoing concerns. However, one of the things that I think came out of the meeting with the groups yesterday was their concern to ensure that the process is not any further delayed. So anything that we do will be in the round to ensure that we are scrutinising and that we are paying close attention to this issue, as opposed to we seeking to delay the launch of the scheme and the rollout of the scheme. So if members were content, I think we should ask for the officials to come probably late September and Capita, which will give us a few weeks to see how the scheme has rolled out. The other issue that we had raised yesterday at the meeting was whether or not there was any need on whether this could be done. And that was for a test case to be taken by the department and it run through the system to see. I suppose the difficulty we have with that is how do we judge it, how do we monitor it, how do we assess it. But I just throw that out to members. And Linda, you want to comment?
Thank you, Chair. First of all, thank you for facilitating the meeting yesterday. And obviously we've had meetings with the groups before, and I think that they are extremely useful. In relation to this issue and any issue where it involves victims, I think that we do need to very much take our steer from them. And in fairness, I think that's what the committee are doing. And what you've just outlined is shows exactly that this is what they've asked us to do. So that's what we're going to be very careful and cautious to do. And I think that's really, really important. One of the other things I suppose came out of the meeting yesterday was the fact that we as a committee will keep a close eye on this. The department has engaged well to date with the victims groups, and I hope that close engagement continues. I hope that they continue to take on board any issues and concerns going forward, and I think it's a really good idea to bring the officials and Capita before the committee, and obviously it is helpful that that wouldn't happen until it has been in place for a number of weeks. And just to put on the record again that we have made it clear as a committee that we are open to the groups, the victims groups, contacting us at any time with any concerns or anything that they feel is not where they're not being listened to. But I would be hopeful that the department will listen to them directly. But we certainly have an open ear to them, and we will take our direction very clearly from the victims groups. Thank you. And just to thank the groups again for meeting with us and being very forthright in what they had to say. Yeah. Thank you, Chair.
Thanks, Linda. And I think too the other issue, which I think if we could agree that would be maybe helpful, is, and again I'm open to suggestions as to how we would do this, but one of the things that has been helpful to committees in the past is, and I understand it's happened here in the committee, is to get someone else to advise who is either outside of or well versed in the particular issue. And I noticed, and I picked it up yesterday, and I had, to be honest, I'd forgotten that one of the reviews that they made reference to was the review that was carried out by Walter Radar in regards to PIP. And then there was another review, and then we have had this report from the Ombudsman. And it's whether or not we get maybe Synergy, or we get someone like Walter Radar or someone else to advise us and to be there to give us independent advice as we step our way through this over the next number of months, because this issue is going to be with us, albeit there'll be a window between September and the end of the year that I think we need to pay particular close attention to. So if we were agreed, would we ask Christian maybe to scope out for us over the next few weeks a few ideas as to what that would look like, how we could procure it, how we could do it, so that we have additional help. And what I was thinking was, for example, if whoever it was, so we'll not define it down to any one individual or any group or organisation, but whoever that was, that they would work alongside the groups that we met yesterday, because they have access to individuals and they would be able to signpost us with their consent to people who would be able to give their experience, their information, And that would give us an independent eyes and ears on this in a way that I think would add value to the scrutiny of the committee. So I put that out to see whether you think that would be worthwhile. Rachel.
Thank you, Chair. Can you hear me okay?
Yes.
Okay, perfect. Yeah, absolutely. I have no issue with any of that. The most recent review was done by Marie Kavanagh and was published there in December. So with Walter, who had done 2016, 2017, published in 2018, and then the most recent one. And I certainly think if the there's plenty, as we all know, there's plenty of evidence of what has happened to people with PIP process, and with plenty of learning to do. It's not a new issue. It's been going on since PIP was installed in Northern Ireland. So I think there's plenty that Capita and indeed the Department of Justice can go on in terms of what can go wrong. So I have absolutely no issue at all with scoping that out. In terms of what yesterday, and in line with the Executive Office's committee's letter, I mean, in our table pack there's a number of questions, and in no way would this be delaying the rollout of the scheme at all. That was loud and clear from all the groups that we met with yesterday, that this needed to be in years ago. It's not, there's no question there of delaying further. But the questions on the practicalities of the scheme and all of those questions that are outlined in the report, we would probably need to get those answered before meeting with the officials.
Yes.
In September, because the scheme will have already started. Do you know what I mean?
Yes.
So those are the kind of issues. I think I appreciate that we're in recess, but I think the department should have answers to, and Capita should have provided answers to well before we meet with them, or indeed the scheme is rolled out, to ensure those concerns are raised.
We'll send those off today, or before the end of the week. Okay, and I think that's a valid point. Yep, thanks for that, Rachel. Robin. And then, just let me check, Linda, do you want to come back in again? Or did you just not put your hand down? You want to come back in? Okay. Right, Robin and then Linda.
Chair, yes, I'm very supportive of the initiative that you had just outlined in terms of bringing some expertise on board. I think that's very definitely a positive way forward. I would just think that, Chair, in terms of as by way of encouragement, and if the committee would agree that yourself would put out a short press statement actually indicating that this is a direction of travel that the committee has agreed, I think that would indeed give some comfort to the victims groups that we're taking all the positive steps that we can take in resolving the issues.
Okay, well, I think we can draw something up and then we can share it with members, and if they're content, I think it will be very short. It wouldn't be detailed, other than to give an assurance that, given the continued public commentary that there has been around this, that we as a committee are paying, and I think it's the point that Linda made, and I think it was made, it really was brought home to me yesterday after the meeting with the groups, that, you know, at the end of the day, these are the people who represent the people that this is about. And I think that they need to be assured that this is not going to be dramatics for us. This is not about us trying to do anything other than ensure that this process delivers for them in the way that it was intended. So I think if Christian's content with that, we'll draft something, share it with members, and if you're content. But my view on this is keep it very short, very focused, to give an assurance to people that we will be the eyes and ears of the scrutiny role in relation to this.
I think that's what's required, Chair.
Okay.
Yeah.
Thanks, Robin. Linda.
First of all, just Chair, on what Robin has just suggested, I think that that's an excellent idea, and the tone in which you just took is exactly the tone that we need to be taking. And I think that, in fairness, this committee has been very united around this issue in terms of how to address it and ensuring that we deliver for the victims, for the people who need it. And that, I think that is exactly the right tone that needs to be taken on it, and it shows that we are united on this issue, and I think that's really important for the victim to understand that, and those who represent them. And then just secondly, yes, I absolutely would support your call for somebody who has expertise and is independent to oversee this, because obviously as a committee we have so many other things going on. I certainly wouldn't like those who we met with yesterday and those who they represent to think that this is just something on a long list. I want them to know that it is important to us that they are delivered for, and that they are delivered for in a manner in which, as all the groups have as their own, I suppose, statement from each group, that they're first and foremost, the most important thing for them is that anything they do no harm to those who they're working with, and we need to ensure that we, as a government who are trying to deliver for them, take the same approach, that we don't do anything that does any harm or further traumatises them. So I think it's an excellent approach, and the statement also, and the tone of it is 100%.
Okay, thank you, Linda. Okay, members, then we'll move to item 2, which is Committee Forward Work Programme, and you'll find that on pages 19 to 23 of the pack, and that's just really for noting. Item 3 is the informal meeting of the children's organisations. An informal meeting was held on Monday the 5th of July with a range of children's organisations at their request to discuss the proposals for the secure justice and care campus and relevant juvenile justice issues. Along with myself, Linda, Sinead, Peter and Rachel, we attended that particular event. A note of the meeting will be circulated in due course. The representatives raised a number of issues and concerns regarding the proposals for the secure justice and care campus and the general direction for youth justice, and these are outlined in the paper at pages 7 to 9 of the table pack. During the informal meeting, reference was made to the research which include youth, the Children's Law Centre, NIAO and VOIPEC commissioned from the universities of Nottingham and the University of Ulster to chart the implementation of the Youth Justice Review recommendations with a specific focus from 2015 onwards. The report outlines the wider concern that the overall trajectory of youth justice policy lacks transparency and strategic direction, and that there are clear gaps in the evidence base on which policy is being formulated. It also includes a section on developments since the review, including the repurposing of the woodlands, which members may find informative. The group have provided a copy of the research for members, and it's at pages 9 to 99 of the table pack. And so, just in reference to this issue, that the research report to the Department of Justice maybe should go to them for a response, and in conjunction with the Department of Health, where this is necessary, and maybe provide a copy of the letter to the Department, to the Committee for Health, if we're agreed. Agreed? Okay, item 4, just check, there's nobody had any comment on that? No? Rachel?
Sorry, Chair. Yes, it was just in relation to the recommendation that would, or the details that, and the issues that the children's organisations had raised with us. And not being presumptive, but I would assume that there will be other issues raised by the Children's Commissioner later on in relation to this campus. So if all of the issues outlined by the children's organisations on top of the ones that, let's say, the Children's Commissioner may also be raising later on, we could raise with the Committee for Health and also with the Department for Justice. And in relation to the tracking of youth justice in Northern Ireland, the tracing the review, I see it was submitted in June. I do wonder if we could also get a copy of the department's response, if any, to that review.
Okay, we will ask. Thank you. Linda? No? Okay. Robin, had you something on this? No? Okay.
No, I'm not sure.
Okay.
No.
Okay, thank you. Item 4 then is the review of the hate crime legislation in Northern Ireland and the report findings and the recommendation. And this is the oral evidence with Judge Desmond Marion. And Judge Marion has agreed to attend today to discuss the findings and recommendations of his substantial report. And I was just saying to him before we came in, one of the committee staff kindly gave me a hard copy of his report, which is 3 volumes. So it was a substantive piece of work, and I think it bears to be considered in that light. And we want to thank him and his colleagues who have put all this together. So the relevant papers for this session are at pages 25 to 155 of the pack. A copy of the Hate Crime and Public Order Scotland Act 2021, which was referenced by Judge Marion, was also circulated to members in advance of today's meeting, and that's at pages 101 to 118. So can I welcome Judge Desmond Marion and Noel Marsden, the Senior Review Manager, to the meeting, and also just to advise that the session will be reported by Hansard and the transcript will be published on the committee webpage. But Judge Marion, it's lovely to see you again. The last time we met, I was in a different role in the policing board, and it's good to have that perspective as well from the police perspective, as was, I think, maybe even Linda, the Vice Chair at the time as well. So you're very welcome to the committee. We have members on Starleaf and ourselves here, so we'll just ask you to make a few opening comments, and then members no doubt will have questions.
Thank you very much, Mr. Chairperson, and Madam Deputy Chairperson, members of the committee. Thank you for giving me this opportunity to provide an opening statement setting out some of the main findings and recommendations of the independent review of hate crime legislation in Northern Ireland. This is the first such review of this legislation, and it is timely in my view, given what I believe to be the current unsatisfactory state of the law in this area. I note you also have been given the departmental response, which is helpful and constructive. And as you've just alluded to, I feel also members of the committee would benefit from a close analysis of the Hate Crime and Public Order Scotland Act 2021, which became law, I think, in April of 2021. On a general point, hate crime law, like all criminal law, must strike a balance between giving the state the necessary powers to protect victims on the one hand, but on the other hand must ensure sufficient safeguards to citizens from unwarranted state control. In recent years, hate crime legislation has been reviewed in all the areas of the United Kingdom. Lord Bracadale reported on the matter in 2018 in Scotland, and after further consultation, the Scottish Government brought forward most of his proposals now enacted in the Hate Crime and Public Order Scotland Act 2021. In England and Wales, although the Law Commission initially reported as long ago as 2014, it was felt by them that a full-scale review involving a more wide-ranging examination of the existing legislation in England and Wales was necessary, and this process continues at the present time, and you may be interested to know that a final report from the Law Commission of England and Wales is expected later on this year. In Northern Ireland, there were similar calls for review of the Public Order, Northern Ireland Order 1987, from a range of sources. A commitment to review hate crime legislation was included in the draft programme for government. And in 2017, the Chief Criminal Justice Inspector noted that a review of hate crime legislation was urgently required. So in June 2019, the Department of Justice set up this independent review of hate crime legislation in Northern Ireland, to be conducted by myself. The remit for the review was to consider whether existing hate crime legislation represents the most effective approach for the justice system to deal with criminal conduct motivated by hatred, malice, ill will, prejudice, including hate crime and abuse which takes place online. I'll just describe briefly the methodology and the consultation process. At the outset of the review, I asked several individuals to form a reference group to help new ideas and as a quality mechanism for the review. This group was split into a core expert group and a group of key stakeholders. The core expert group included several leading academics in this field from the United Kingdom and Ireland, also senior representatives of the PPS, the PSNI, the Department of Justice and Victim Support. This group met regularly, scrutinising and challenging emerging ideas to ensure that any final recommendations would be robust, fair and practicable. At the heart of the review was public consultation. A consultation paper was published in January 2020, and I commend that to the members of the committee because it provides a great deal of background information not included in the final report. It also had an online questionnaire, and despite COVID, in total there were over 1,000 responses from organisations and individuals to this process, some idea of the importance that the stakeholders and the public regard this important subject with. The review team then organised a series of public outreach events throughout Northern Ireland from January to March 2020, providing vital input for the review. From the outset of the work in June 2019, the review team met or had discussion with a large number of organisations and individuals. The work of the review received significant publicity in the media, including a number of interviews at key stages. I also met with the Law Commission and with Lord Bracadale to consider their views. I then moved to what I call the shortcomings in the current law in Northern Ireland. From an early stage in the review, it became clear to me that unlike other areas in the United Kingdom, in Northern Ireland there is no specific criminal offence for hate crime and no legal definition of the term. Leaving aside public order legislation, which is quite separate, and the Justice Act Northern Ireland 2011 dealing with indecent, racist or sectarian chanting at regulated football matches for the moment, hate crime is only addressed at the sentencing stage in this jurisdiction under the Criminal Justice No. 2 Northern Ireland Order 2004, which enables a sentence to be increased where it is proven that the basic offence for which the person is being convicted was motivated by hostility against one of the currently protected characteristics, that is, race, religion, sexual orientation or disability, or where the offender demonstrated hostility against one of those characteristics either at the time of committing the offence or immediately before or after it. The scale of the problem of hate crime in Northern Ireland is significant. The Criminal Justice Inspectorate has found that when population is considered, the figure of recorded hate crimes is actually higher than the equivalent rate in England and Wales. In that jurisdiction, it is estimated that over 80% of hate crimes are not reported for various reasons, and there is no reason to believe the situation is any better in Northern Ireland. The current ineffectiveness of the law, I believe, is likely to be one of the main reasons for the poor level of reporting. As regards the main findings and recommendations, somewhat surprisingly in relation to incidents that are reported, since 2018 racist hate-motivated incidents have actually overtaken sectarian hate-motivated incidents in Northern Ireland. When one considers the proportion of the population from a black or multi-ethnic background, the reality is even more stark. There is approximately 1 in 31 chance of being the victim of a reported race hate incident, compared to approximately 1 in 1,700 chance of being a victim of a reported sectarian hate incident. The main finding of this review, right at the core of the review, is that hate crime law in Northern Ireland, such as it is generally ineffective and requires urgent, substantial reform, including legislative change. And I believe that without such change, the law will continue to fail victims and society generally. It is now some 16 years since the introduction of the 2004 order. It has been the subject of widespread criticism over many years and, in my view, is not fit for purpose, nor is it capable of being reformed. If I could give the committee a practical example of what I mean by such a statement. The review team looked at the transcripts of the sentencing process of Crown Court cases for the year 2018-2019. These are cases identified by the Public Prosecution Service as cases aggravated by hostility against one or other of the protected characteristics. 16 such cases were identified by the PPS to be dealt with at the Crown Court level. Of those 16 defendants, the PPS only in fact eventually prosecuted 4 of them on the basis that the alleged offence was aggravated by hostility. None of the defendants who were convicted received an increased sentence as the law intends, where the judge accepted that the aggravating feature of the offence had been proven beyond reasonable doubt. As I say, only 4 of these cases were actually prosecuted as offences aggravated by hostility. And whilst the judges in those 4 cases accepted that the aggravating features had been proven and said so in open court, they did not give a greater sentence, or if they did not state they were doing so. I have recommended that it would be much better to tackle hate crime through a new model, or what is called an aggravated offence model, i.e., where a hate crime aggravation can be added to any offence and tried as such. This would not require any additional increase in sentencing, in maximum sentences. But this particular model brings the hate element into the trial itself and does not simply leave it to the sentencing stage, which has failed. This will encourage the police to collect evidence of hate at an early stage, something that does not appear to happen regularly under the current arrangements. It means also that aggravation will appear on a defendant's record, but gives better protection to the defendant, as it requires the prosecution to prove the aggravation at the offence stage in the Crown Court before a judge and jury, which fits well with the legal doctrine of fair labelling. In this respect, I believe the Scottish model provides an excellent template. It's been in operation for many years, and it can deal with any offence, not just the limited suite of offences currently dealt with in England and Wales as aggravated offences for race and religion alone, under what's called the Crime and Disorder Act 1998. I note that this key recommendation, the core of this review, has been accepted by the Department of Justice. Current legislation refers to the notion or the concept of hostility against one of the protected groups. I believe that a wider range of attitudes should be introduced, such as bias, prejudice, bigotry, or contempt. The current thresholds for proving that these aggravated offences are demonstration of hostility and, secondly, or alternatively, motivation. Experience in England and Wales has shown that motivation is extremely difficult to prove. I am persuaded that a third test, the so-called by reason of threshold, should be added. This is particularly important for the protected characteristic of disability, where prosecutions are very rare under the current law in England and Wales. The current protected groups, both in relation to the 2004 sentencing provisions and public order legislation in Northern Ireland, are, as I say, race, religion, sexual orientation and disability. And I recommended that these protected groups should continue to receive protection together with new recommended protected characteristics of age, sex, gender and variations in sex characteristics. Provision should also be made, in my view, for any future legislation to be framed in such a way as to allow any other protected characteristic to be added to the list by statutory instrument if there is sufficient evidence emerging to show such a group or groups are victims of hate crime or hate speech. As regards the proposed new characteristic of gender/sex, I believe there is a very strong case to be made for the inclusion of this category, given the wealth of evidence of hateful targeting of women, especially online, and the additional harm this causes. Including gender mainly to give protection to women would send a very strong message that trolling, sexual harassment and hate directed against women will not be tolerated. Gender per se is not a protected characteristic in any of the other countries of the United Kingdom or Ireland, and I believe that this is an opportunity for Northern Ireland to take the lead in protecting women. I do acknowledge that there are some practical concerns in certain contexts, such as in domestic abuse and sexual offences, but these issues can be resolved. Gender would also include transgender identity. This, in fact, is the only part of the United Kingdom where transgender identity is not given some form of protection. The PSNI collect figures in relation to incidents and crimes against transgender people, and these figures indicate that hate crimes committed against these folk are on the increase. The Department has accepted that transgender identity should be included as a protected group. On a more general level in relation to gender, in his review of hate crime legislation in Scotland, Lord Bracadale recommended the inclusion of gender as a protected group. The Scottish Government accepted the evidential base for this, but they did not follow his recommendation fully. And I understand the reason for doing that was that they had already given a promise to women's groups to consider introducing a new crime of misogynistic harassment. However, there is provision, as you will see, in Section 12 of the Scots 2021 Act for the addition of sex at a future date. I conclude that there is also a good case for adding age to the list of protected characteristics, meaning a range of ages, in view of the challenges faced by older people in the form of elder abuse and age discrimination. particularly if the concept of hostility is widened to include concepts such as prejudice and contempt. Age is now included as a new protected characteristic in the Scots legislation. Some people argue that people do not hate or are not hostile to older people. On the other hand, I believe that targeting a group due to an actual or perceived weakness or vulnerability is a form of contempt or hatred in itself for that group, and displays an attitude of hostility based on active disdain for members of that group. In this context, the importance of intersectionality should be reflected in the drafting of any new statutory aggravations. This is where hate crime is committed against someone on the basis of more than one protected characteristic. As regards sectarianism, the findings of the Working Group on Defining Sectarianism in Scottish law, produced in November 2018 and chaired by Professor Duncan Morrow of the University of Ulster, should be applied in Northern Ireland, in my view, subject to any necessary adjustments. In the New Decade New Approach Agreement of January 2020, the parties indicated their wish to see sectarianism given legal expression as a hate crime. The current religious group indicator does not adequately capture the meaning and impact of sectarianism, which extends beyond religion to include aspects of nationality and political identity. This proposal is accepted in principle by the Department. I have recommended also that there should be a clear and unambiguous statutory duty on relevant public authorities, including councils, the Department of Infrastructure and the Housing Executive, to take all reasonable steps to remove hate expression from their own property and broader public space. In this respect, you will know that it will be important to consider the report of the Commission on Flags, Identity, Culture and Tradition, arising from work done by that group over a 4-year period, 2016 to 2020, and sent to the Executive Office in July 2020. The Public Prosecution Service and the Police Service of Northern Ireland agree with my recommendation in this regard. There is also a significant gap in the law in Northern Ireland regarding restorative justice. It is provided for offenders under 18, but not for those over that age. I have recommended that there should be a new statutory scheme for restorative justice generally, not just for hate crime, for over 18s to meet this gap in the law, and that it should be organised and delivered by a statutory agency similar to the Youth Justice Agency in Northern Ireland. The Probation Service appear well suited for this task, with the presently accredited restorative justice groups continuing to provide community support and support to the statutory agency, which would take the lead in any such collaboration. As you know, these groups are currently Community Restorative Justice Ireland and Northern Ireland Alternatives. Victims have constantly argued for effective victim-led restorative justice, which often may have better outcomes for low-level hate crimes than imprisonment. Turning then to the question of hate speech, which is a completely different genus to hate crime, the Public Order Northern Ireland Order 1987 relates to what are called the stirring up offences, i.e. the stirring up of hatred or arousing fear, conduct which encourages others to hate a particular group. It should be noted that this legislation has been little used over the years, not only in Northern Ireland but in England and Wales and in Scotland. There appears to be limited awareness of the law. Although the law in this area is rarely used, it does raise important issues around freedom of expression. Real and genuine concerns were articulated to me by several faith-based groups. It is crucially important to reiterate that the issue of freedom of expression has a central role to play in ensuring fairness between the complainant and the defendant in compliance with the Human Rights Act and international treaty obligations. And I fully accept that freedom of expression and equality rights provide the fundamental legal framework for considering hate speech. Setting the correct balance and protecting human rights, whilst at the same time addressing hate speech, is one of the most important and challenging parts of this review. The value rightly attached to freedom of expression requires very careful appraisal, and in Chapter 9 I devote no fewer than 56 pages to consideration of this key issue. I have advocated that there should be a formal statutory recognition in any new hate crime law on the importance of freedom of expression under Articles 9 and 10, i.e. the freedom to exercise one's religion and the freedom of expression, and all the other rights guaranteed by the European Convention on Human Rights and Fundamental Freedoms. And I remind the Committee that the European Court of Human Rights has confirmed for many years that there must be a right to shock, offend or disturb. In respect to any new consolidated hate crime and public order law, scrutiny and oversight, I believe, are crucial. I have recommended that there should be post-legislative scrutiny by the Assembly through this committee and other groups to monitor the effectiveness of any new legislation which is eventually passed in the next mandate on hate crime and hate speech. I recommend that such scrutiny should occur regularly and formally at 3-year intervals and, if possible, include an element of public consultation. Finally, I have further recommended that consideration should be given to establishing a hate crime commissioner for Northern Ireland, and that such a role could properly be shared with domestic abuse. In its response to the review, I note that the Department of Justice has stated its view that instead of that, there should be a Victims of Crime Commissioner with a particular emphasis or focus on hate crime, sexual abuse and domestic abuse, and I would strongly support this alternative proposal. Mr. Chairperson, that concludes my opening remarks.
Thank you very much. And again, a word of appreciation and thanks for all the work that has been done in relation to it. It's interesting to note that in terms of the Scottish proposals, they have now made some additional changes.
Yes.
Because there was some concerns that were raised. I noticed that they have agreed to limit the offence to intentionally stir up hatred.
Yes.
I think that was a welcome move, because you're well aware that, take for example the issue of the Public Order Northern Ireland Order 87, in the responses to the recommendation for the repeal of that, in your own report, there was 97% of people who said that it should be retained. And I just wondering how, and I suppose this ultimately is an issue for the department, as to how we will strike that balance, because in all of these things, it is about balance, it's
yes.
proportionality, and there has been a considerable degree of concern raised both in what happened in Scotland and in terms of what may possibly become the end point in terms of legislation. So do you, in the light of, we have your report, we have now seen, and I take that you've only seen it recently, but we have the first draft, at least from the department, as to where their thinking is, although it is littered with, it is, it should be given consideration to. As most things, the department is not completely and absolutely definitive as to where this may land. But do you believe that there is some adjustments that could be made, even on the basis of the recommendations that are already made, that would make it easier for the drafts people to come up with a piece of legislation that would have more buy-in across the piece, as opposed to where we may be with some elements of the proposals?
Yes. Well, two things. First of all, in relation to this, the bill introduced in Scotland, they did not have in that bill a specific reference to, explicit reference to Articles 9 and 10 of the European Convention, freedom of expression of religion and freedom of expression. And I don't know whether they poached it from my consultation paper, but it looks like they might have, because now you'll see right front and centre in their Act, they've now, having never mentioned it before, they now have it. And I don't take any particular credit for that. But to be serious, the thinking behind that is, I understand there's great sensitivity among faith-based groups. I mean, thinking particularly of the Evangelical Protestant Society, the Christian Institute, and other groups. What they're concerned about is that an over-rigorous public order legislation might have what they call a chilling effect on the ability of pastors, ministers, priests perhaps, to criticise other religions. And they note that, for example, in England and Wales, there are specific defences, which I haven't recommended here, and I'll explain why, specific defences in relation to the criticism of other people's religion or sexual orientation or same-sex marriages. Now, the reason I haven't included it is not because I don't understand those concerns. It's precisely because I do understand those concerns that I devoted 56 pages to looking at this issue. And I came up with the following line of thinking. First of all, the changes in the law in England, which have been there for many years now, we've never had those in Northern Ireland. Since 1987, in the public order legislation, we've never identified particular protected characteristics. You'll remember that they're sex, religion, race, religion, sexual orientation, and disability. And we've never prioritised any particular protected characteristic in that way, adding a special protection for it. And I have seen no evidence in the 33 years that our law has been in operation that has worked to have a chilling effect on the right of various religious people to criticise other religions. On the other side, I also see that academic writers, including the Law Commission, have recently indicated that the introduction of those specific defences has in fact meant that it makes the law very difficult to prosecute anyone in relation to those particular areas, so that it may be damaging the purpose behind the law. But understanding the sentiment and the very exquisite concern that those folk have, quite rightly, good folk have, I have suggested formally referring to the European Convention of Human Rights. Because, as I said earlier on in my remarks, for 30 years now, since a case called Handyside was decided, the European Court said everyone should have the right to shock, offend and disturb. And I would have thought one could make a criticism of another religion quite easily by shocking, offending and disturb without going the extra mile. What do I mean by the extra mile? Well, it may interest you to know that in England and Wales, the so-called religious defence allows those who wish to criticise other people's religions not only to do that, to shock, offend, disturb, but to actually abuse other people's religion. And that's a word that, particularly in Northern Ireland, I find a bit chilling. I don't see any reason why we shouldn't. If you want to criticise someone else's religion, say that Islam is wrong, idolatrous, whatever you want to say, or make similar criticisms of Christianity, good luck to you. You're perfectly entitled. That's what living in a free democratic society means. But to go further and to abuse someone else's religion is too far. The European Court has said it's too far, and I don't really understand why it's there in the law in England and Wales. And the other thing I'll say just on that is that I think to pick out individual characteristics and create special offences for them offends against the principle of fairness. I think that if you're going to do that, you may as well provide the same protection for other protected characteristics. But I think it is a very important area, and I know this committee and the Assembly will give it very close consideration. It is very important to know how to strike the balance, and I think the best way to strike the balance is to make sure that in any proposed legislation, Article 9 and 10 rights are there enshrined in the law and with explicit reference to the European Convention. I hope that goes some way to answering your point.
That's very useful, because I'm led to believe that in I think it's in the English equivalent, it actually talks about ridicule and insult.
Yes.
Which is, akin to what you've made reference to in terms of
but it goes further, Mr. Chairperson.
Abuse.
It includes the word abuse. And the word abuse in the Oxford Dictionary is something like, the description is to vilify another person. And the last thing we need in Northern Ireland is people going around vilifying. Yeah. Now, even though the prosecutions are very rare. And the other thing I would point out to the committee is this. The duties under the European Convention before you take a prosecution, before you introduce a law, and then before you take a prosecution, are very strict. And that's why the number of prosecutions is only 5 or 6 a year. I think last year in England and Wales there were 11 prosecutions. And look at the population of England and Wales. Look at all the various criticisms there are of religion in England and Wales. Yet they only managed to bring 11 prosecutions, which either shows the law is working well and that people obey the law, or it shows you that this is actually quite a small area of concern. But even if it is a small area of concern, I know that the folk who have a particular interest in religion regard the freedom of expression to express their antipathy towards other religions as vitally important. And I wouldn't be sitting here justifying these recommendations if I didn't think that what I had proposed adequately protects that.
And leading on from that, there is the issue in relation to one of the recommendations in regards to the Director of Public Prosecutions be personally involved in any decision to prosecute offences of stirring up hatred.
Yes.
Do you think that in a sense, if that was to be implemented and that was to be the case, does that by practice undermine the very intent in relation to freedom of speech, because it is in a sense coming to a conclusion before the decision has been made?
Well, first of all, on the general question of the personal, at the moment the law is in England that the Attorney General must give personal permission, position in to bring a prosecution. The law in Northern Ireland is different. The law in Northern Ireland was changed a few years ago to take it from the Attorney General, who of course is responsible to government, to the Director of Public Prosecutions, who isn't directly accountable to government. But a decision in the Northern Ireland Court of Appeal ruled a few years ago that the Director of Public Prosecutions could delegate that power to a senior member of staff, or if he wished, he or she wished. I think that the issue of freedom of expression is so important and the number of prosecutions so small that it should be a personal decision. I don't think it would cause any increase in their workload, and if it did, well, so be it. I think it's such an important issue, and that means that the Director would have to look at each case, each file in which there was going to be a prosecution or a prosecution was recommended, and apply the European test of proportionality to that particular case, and that would give an added buy-in to the protection, ensure that only those prosecutions where egregious behaviour had occurred, behaviour likely to, where the intent was to stir up hatred, would actually end up in the courts.
Okay. Peter?
Yeah, very interesting. A couple of questions, I suppose, following on. I suspect, I might be wrong in this, but in terms of the different approach taken in England and Wales, particularly on the issue of how far you can go in terms of freedom of expression as regards religion.
Yes.
I suspect that part of the motivation may be less directly that situation of, for the sake of argument, one religious figure attacking a sort of another religion, as opposed to whether it's a level of protection that I think there's clearly elements of it within Northern Ireland, but a stronger issue within England of those who would come from a very secularist or anti-religious point of view, having a level of freedom of expression. And I know that whenever at times there have been examinations of either hate crime or even blasphemy laws, as much as the particular issues have been raised by various religious groups, it's quite often been by some who would come from a satirical background or whatever, taking a high level of particular perception in relation to that. I wonder, you mentioned, I think, very clearly, I think part of the issue with a lot of this will be striking the right level of balance. And I suppose in a different sphere on that, clearly as regards a range of hate crime issues, there will be what is explicitly prescribed in law and therefore be part of the legislation, and then where the level of interpretation will be there within courts. Yeah. And I suppose, there's a wider, we raised this recently with the Lord Chief Justice, that there will be a tension there sometimes between politicians and judges as to whether there's a certain level of mission creep at one level by judges, or alternatively a feeling from the judiciary that at times politicians, elected representatives are almost trying to override what is a sort of a form of natural justice. I wonder if you have any thoughts particularly around this area as to where you feel the balance of precision should be in terms of the issue of how far we go in terms of how explicitly we legislate and how much is left to the level of discretion of the courts, albeit then with the sometimes complaint in a range of things of this was never intended in the first place type scenarios.
Well, Mr. Weir, two things in relation to your answer, and I hope I am answering your question as directly as I can. First of all, judges... I
should say as well, I mean, if you don't, you may well find your place on the Assembly Committee rather than as from a legal background in that regard, if you're avoiding answering a question, but go ahead.
So far as the courts are concerned, they, like any public authority, are bound by the European Convention. Under the Human Rights Act, they have a duty to apply the principles of the European Court. And a very good example of that, which I thought would allay the fears of some in the evangelical community, was a decision of Miller and Humberside Police last year, in the spring of last year. Very briefly, Mr. Miller was engaging in somewhat offensive tweets back and forward. He disputed the basis of transgenderism, and the person who was at the receiving end sent back one or two pretty offensive tweets to him. But the person who was the transgender person complained to the police that this was a hate because transgender is protected in England. And the police came to his door, in fact to his place of work, and then they sought an interview with him. They recorded it as a hate incident, not a crime, because no crime had been committed. But they warned him that if he continued to send tweets like this, there could be an escalation as far as he was concerned. And then he demanded an interview with senior police, and they also confirmed that there could be an escalation, and that they had recorded the incident in their papers. Now, the judge in the case, and Mr. Miller challenged this on European Convention principles. The judge, Mr. Justice Knowles, who heard the case in England last year, ruled that police were allowed to record the information as an incident, but that what they had done beyond that was unlawful. They should never have gone to his place of work. They should never have indicated to him that there could be an escalation. In other words, they told the police they'd got it wrong. And even the fact, Mr. Miller won, which indicates that the courts are, root and branch behind principles of freedom of expression. That was a freedom of expression case in which the outcome was entirely satisfactory to Mr. Miller. Mr. Miller has taken a point to the Supreme Court, which has not yet been heard. The Supreme Court said that it should go first to the Court of Appeal. The issues were raised in March of this year, although judgment hasn't been given. And why did he take it, since you would have thought he's won the case? He took it on a separate point, and that is, should the police be able to record incidents of hate, alleged incident of hate, simply on the word of the person who allegedly suffered it? The answer that the court gave in the first case was, well, yes, they can, because the police need to show that they have a record of the incident. But what Mr. Miller's concerns are, and ones I would share, would be the suggestion that that record the police have could somehow make its way on to the police national computer. It could possibly be used against a person if they were looking for employment. I'm assured by the police, and I've gone to the highest level on this, that that is not the way it works. They do keep it as a record, but it can only ever be revealed on a very, very stringent basis. I still have concerns about that. But I simply give you that example, that particular case is an example that, in my view, the courts, by and large, do take their responsibilities to apply the European Convention very seriously. I hope that goes some way to answering you.
Yeah, the second point, just on a slightly separate point, you mentioned that, and I know there was a level of controversy, some people take slightly different views on in terms of what is the thorny question of definition of, because I think everyone can accept conceptually the idea that we should be doing all that we can to prevent sectarianism. I suppose the devil becomes the detail of how exactly you define that. And within Scotland, you give the example that within Scotland there's been a definition which at times at various stages has had levels of controversy, and you indicated that you felt that broadly speaking that should be the route of direction, if you like, for Northern Ireland, but that I suppose to some extent it would take account of the particular circumstances. Yeah. I just wonder in terms of where you see the particular variations here between Northern Ireland and Scotland in terms of how you would see that being applied or perhaps defined.
You're talking about sectarianism now?
Yeah, I mean, you mentioned, if I picked you up right earlier on, you'd said that
yes,
you felt the definition of, that there was an NDNA commitment in terms of the issue of sectarianism, and as part of that, there had been, after presumably a little bit of refinement, essentially a template, if you like,
That's
Scotland,
right.
but that there may need to be some level of I'm not exactly putting words in your mouth, but sort of paraphrasing here, but there may need to be some level of adjustment to that, to take account of the situation in Northern Ireland, that it wasn't quite just grafted onto Northern Ireland as a one size fits all. So I'm just interested in your thoughts in terms of where you see the potential variations from where we'd be in Scotland.
Well, there wouldn't be much variation, to be honest. It was really a legal technical thing. In Scotland, they have their laws slightly different. The actual definition and the principles that Professor Morrow and his group set out, I agree wholeheartely with, and indeed so does the PSNI and the PPS. And as I pointed out, the New Decade New Approach Agreement of January 2020, it appeared that the various parties to that agreement suggested that at last in Northern Ireland we should have a sectarian indicator, because goodness knows all of us deprecate sectarianism. We're always saying that. But the only time it's ever mentioned in any legislation was in the Justice Act 2011, where there's an offence created of sectarian, racist or indecent chanting at regulated football matches, soccer, rugby and Gaelic. There's never been a prosecution under the Act, which is maybe a good thing, I don't know. Maybe it means people are listening to what the law says, or it may not. But when the Assembly tried to agree on a definition in 2011, they couldn't get agreement. And I was just hoping that by this stage in our development, on further reflection, we may be able to come to an agreement on a definition along the lines Professor Morrow, who's from the University of Ulster.
It's really a question of looking at whether there might be technical tweaks rather than any change of substance.
I don't think it'll be anything substantive.
Okay, thank you, Chair.
Thank you.
Thank you. Linda. We'll bring Linda in by Starleaf.
Thank you, Chair, and thank you to Judge Marnan for the report, first of all, and the recommendations, and also for coming before the committee today. Really appreciate it. I have a couple of points just in really, and some of them you've sort of probably partly at least addressed. So if I'm going back over stuff, I apologise. Just suppose first of all to state that our party fully agrees with the statutory aggravation model for all offences, and that should be developed. And you have talked a little bit to this. There is a fear that where the hostility or contempt element of a crime is more difficult to prove than the substantive offence, prosecutors might sometimes choose the easier option and disregard the aggravation and prosecute only for this substantive offence. I'm just wondering, have you any suggestions on how that could be mitigated against?
Well, first of all, good afternoon to you, Ms. Dillon. In relation to the current situation, the problem with enhanced sentencing is that the issue of the aggravation doesn't arise during the trial. So you could take a simple example. You could have someone charged with a Section 18 wounding, very, very serious offence, which carries a maximum of life imprisonment. Under our current sentencing law, the jury never hear about the aggravation during the trial. The prosecutor doesn't develop any aspect of that. The police don't even necessarily collect information or evidence around that. And at the very end of the trial, when the man is, usually a man, when the person is either convicted or pleads guilty, the prosecutor stands up and says for the first time to the judge, "Judge, I would like you to consider an increased sentence because we suggest that this crime is aggravated by hostility against race, religion, sexual orientation or disability." If the person doesn't accept it, and normally they won't accept it, then there has to be a trial within a trial where the judge, on his or her own, without the jury, without that democratic background of a jury, then has to decide beyond reasonable doubt whether the aggravation is proven. And in that situation, the defendant is in difficulty because if he's pleaded guilty, he gets credit for pleading guilty. But if he doesn't plead guilty to the aggravation aspect of it, then he could lose credit. So it's really not very fair on the defendant as things stand. And therefore, and overarching all of that is the fact that, as I've demonstrated, and Mr. Marsden, who's a senior review manager, and I spent many hours in the records of the Department of the PPS looking at the actual files of these 16 cases. And I was quite shocked that only 4 of them had been prosecuted as hate crimes, even though someone in the PPS had originally thought that there were 16 of them. And I was even more shocked by the fact that even when those 4 cases were proved, the judge did not appear to increase the sentence, certainly made no reference to the law or increasing the sentence. Now, the point about introducing the new model, the aggravated offences model, is it becomes that Section 18 wounding now becomes Section 18 wounding aggravated by hostility. So that is in the indictment. That's what the jury see. That's what prosecuting counsel will open. So there's no question of it being forgotten about or downplayed. And it also means the police, from day one, from their investigation, will be investigating it as a hate crime from the very beginning. So the evidence is going to be gathered. And therefore, there's a much, much higher chance of cases reaching court and being dealt with seriously and appropriately. And that's the beauty of the new model. We're saying a new model. It'd be a new model for Northern Ireland, but it's been a model in place in Scotland for many, many years, and to a lesser extent in England and Wales. And it works really well in Scotland, so there's no reason to think it won't work well here. And I was quite pleased to see that the Public Prosecution Service wrote a long piece in their contribution to the review, agreeing with those sentiments, and in fact had done work with their Scottish colleagues and were perfectly satisfied this was a much better way to ensure not only prosecutions went ahead appropriately, but also fairness to the defendant.
That's brilliant. I appreciate your answer in relation to that. And I suppose it comes down to, and I think your recommendation around that review. I mean, it's been something that's been very important to this committee around other pieces of legislation, that element of review, and I think it's 100% right. And we probably need to ensure that the policing board, of which both myself and the chair were members, keep an eye on that in terms of the police, to ensure that they are treating it as a hate crime and investigating them as hate crimes from the very beginning, so that there is enough evidence then for the PPS to bring that forward.
If you don't mind me, sorry to interrupt. Yeah. If you don't mind me adding, it's also gratifying to note that the Police Service of Northern Ireland also support the change in the law. They recognise too, as does the PPS, the law's not working. And this has a knock-on effect. It means victims are then fed up. They don't go to the police and raise these issues because they know it's not going to work for them. So it's a win-win situation, I think, if we introduce a new type of law.
I think you're right, and I think whenever there isn't good law, the police end up invariably being the people who get the blame for not delivering for people on the ground, because they don't see past the police response to it. So I think you're right, and police do need good law in order to be able to have, I suppose, a proper process in terms of investigation. Just around the sectarianism issue, and again, I mean, we do support the new legal definition of sectarianism. The need for the statutory aggravation of sectarian prejudice could also raise the issue again around the department had said to us that this needed to be in conjunction with the FICT report, and I know you did say that in your opening remarks. I'm probably a wee bit concerned just because I'm not sure where FICT is at and if we're ever going to get recommendations from them, and I would be concerned that this would be held back as a result of that. And you've said it yourself, I mean, we need something in place. We need to have a clear legal definition of what sectarianism is and in relation to hate crime. And again, I would say that this is something that the PSNI need, because I'm sure all of the elected representatives on this committee will have the same challenges whenever their constituents are complaining to them about different things, whether they're posters or flags or whatever they are, that the PSNI are saying they don't have legal cover to deal with them. And I think that we have to bear some responsibility for that. And if we delay on this, then we're going to continue to have that situation. So I'm just wondering what your view is on in relation to that. If it is a case that FICT is going to hold this back, how do we deal with that, or should we just move ahead with it in the legislation?
Well, I have to pick my words carefully. I think I'll dodge the question of when the FICT report should be released from the Executive Office. I'm not a politician, and I think I should stick to my own brief. So apologies for that. But let me put it more diplomatically. It would certainly be of great use to this committee and to the Assembly generally if the report could be shared. It took 4 years to produce. And one might argue that a year is long enough, and maybe I've said too much. But it would certainly, to be serious though for a moment, there is you'll see the departmental response, both on sectarianism and on hateful expression in public places, both references the fact that they're waiting for they want to link this work that we've done in the review with the FICT report on these two key issues. It would certainly be most unfortunate if the work of bringing forward a new public order and hate crime bill were to be unduly delayed by waiting for the FICT report. So I would earnestly hope that this can be produced to you and to the Assembly in a reasonable time frame.
Yeah, I mean, I agree with you, but I certainly wouldn't want to see us delayed on the basis of that. I
should also say, Ms Dillon, that if, for example, issues like sectarianism and hateful expression in public space are further delayed maybe for good reason, by the fact that the FICT report isn't available, I would very much hope that this committee and indeed the department would press ahead with a hate crime bill in any event, because there are many, many other pressing issues that don't depend on the FICT report.
Okay, thank you for your views around that. Just one other issue to raise, Chair, if that's okay. Yep. Just on the restorative justice piece.
Yes.
I agree with you that restorative justice is vital. I think that it works because it is community, it's based in the community and it works from the ground up. I know that you have talked about it being on a statutory basis, and I'm certainly not hard and fast on this. I do think it's important that we retain those ground up community rooted organisations, because I think that's why it works. And I know we had this conversation actually whenever I was on the policing board, and to be fair, I think that you agreed with that, but I just want to put that on the record that that is something that you would view as necessary.
Yes, well, there's no doubt that the community-based groups, the Community Restorative Justice Ireland and Northern Ireland Alternatives, do a fantastic job. They've been commended by the Criminal Justice Inspector and various other reports over the years. But I think one has to bear in mind that if one's talking about restorative justice for over 18s generally, with court-ordered dispositions and reports back to the court, it seems to me vitally important that there be a statutory agency, probably the Probation Board, who can do that, because the Youth Justice Agency is a statutory agency, independent, that does that work for under 18s. And although the community-based restorative justice groups do fantastic work, remember where they come from and where their main focus is. They were set up originally to deal with basically paramilitary type cases. Some of them have a background, some of the excellent people who work on them have a background from their previous lives in paramilitaries, and they do a fantastic job of preventing young men mostly being kneecapped and all that sort of that dreadful sort of business. But that doesn't apply to other groups who need protection, like disability, transgender, gender, age. Those are people who do not, who need to have the reassurance that a statutory group will deal with their cases. And I also point out that the community-based groups are based geographically in very small areas in West Belfast, North Belfast, Derry, London, Derry. The geographical reach that they have is not great, and I don't see any reason why the two groups, that is the statutory group that I propose and the community-based groups that you're talking about, can't work together. But I do think the statutory group should take the lead. Mr. Marsden here, who's accompanying me today, has in fact been appointed as the policy lead for a Restorative Justice Working Group, which is at the moment actively considering what proposals to bring forward. And I see no reason why there shouldn't be both a place for the statutory organisation, particularly in relation to referencing cases to courts and back from courts, and also a key role for the community-based groups, who do excellent work.
Appreciate that. Thank you very much, Judge Martin, and thank you, Chair.
Thank you, Linda. Gemma.
Thank you, Chair, and thanks, Judge Martin, as well, for coming today and for your work on this. You've already touched on this briefly in your opening remarks. It was about the evidence showing that crimes against older people are often based on their perceived vulnerability and not their age. So in light of that, what's your rationale for recommending age be added? And linking into that, do you think this would in any way dilute the legislation from its intended purpose?
Yes. Well, I'm glad you asked that question, because I know this is a controversial issue. Many people disagree with me on the question of age. But I do point out, firstly, that in Scotland, a similar jurisdiction, bigger than ours, this was explored very carefully, and an evidence base was generated. And Lord Bracadale was persuaded to include age, and the Scottish Government have included age. So that's the first country in the UK or Ireland which has included age. So it's not just a flight of fancy of mine. There is, in fact, an evidence base for it. Secondly, it depends what you mean by hostility. If you mean by hostility towards a particular group of people that for example, I'm 72, going on 73. I don't feel that people are going around hating me or being hostile to me. I saw in the paper today that pensions are due to be increased by 3%, and therefore some people may feel a bit resentful. You younger people feel a bit resentful about that. But to be serious, nobody really hates older people. How could you? It's like hating mum or apple pie. But what I do strongly believe, and there is evidence for it, and the Commissioner for older people in Northern Ireland gave a very, very helpful contribution to the review, in which he indicated that if you move away a little bit from the word hostility, if you add in, as I propose, words like bias, prejudice, contempt, I have no doubt whatsoever that there is considerable bias, prejudice and contempt. People who decide to break into older people's homes, to assault them on the street, to pick out an older lady on the street with her handbag as opposed to a young, healthy woman who might be able to defend herself. They're displaying, to my mind, hostility, disdain towards those people, which I equate to hostility. And so if you expand the concept a little bit more to include prejudice, bias, or disdain, or contempt, then I believe that older people should be protected. And indeed, there's a lot of evidence that older people are frightened in their homes, that they are less willing to engage socially. And I think this would be a wonderful opportunity, both for them, but also for women coming on to the gender issue, to show that the Assembly cares about them and is not going to put up with this any longer.
Thank you. That's really useful, and I wasn't disagreeing with you, and you don't look 72 either, so you can take that.
Well, that's very kind of you. My wedding anniversary is tomorrow, so I'll remind my wife that you said that.
No, that's my questions, and thank you very much for that answer. Very useful. Thanks, Chair.
Thank you. Rachel.
Very much. Thank you so much.
Thank you, Chair, and thank you, Judge Marnin. On a recent point, I'm not a fan of apple pie. Controversial, but thank you for your attendance today and also for a fantastic review. I've made my way through the second volume, but looking forward to finishing it entirely. It's very, very comprehensive.
Well, you'll soon have the whole summer holidays to read all of it.
Oh, yeah, plenty of time, obviously, yeah. Some light reading. A number of questions have obviously been asked over different issues, and it is a huge piece of work, so I just got to pick up on a few. But there are two key legislative issues under the theme of the new hate crime model for Northern Ireland, as highlighted in, I think it's Annex A of the Department of Justice's brief, which we got, which concern your recommendations number 6 and number 9, that the Department are saying need to be considered further. And that's regarding the introduction of a third threshold for proving an offence is aggravated. And the Department have said that if taken together with further protected groups based on age and gender, this could potentially make the test too broad and dilute the symbolic power of specific hate crime legislation. And I'm just wanting your opinion on that. What do you think of that conclusion by the Department? And do you accept that argument?
In short, no, I don't. I appreciate the Department have produced a very elegant, well-constructed and thoughtful response, and I'm not making light of that in the slightest. They're only reflecting the views of many people who responded to the consultation paper. And in essence, what I'm saying there is, I'm giving you a practical example. So at the moment, the two features that we have to employ in the law in England and Wales or Scotland is either an intent to hate or to show hostility towards a protected group, or a demonstration of that. Now, a demonstration would be, for example, if you shouted something offensive about someone because of their race or their sexual orientation during an assault on them, then that is clear evidence of a demonstration. Intent is a much more slippery beast, and in fact, take disability, which is covered under our legislation at the moment. How do you prove intent against a disabled person if someone kicks a disabled person, steals their wallet and goes away? They've probably picked them, it's very like age, they've probably picked them because they see them as vulnerable, because they have contempt for their status, their weak status, or what they perceive to be a weak status against those people. And to deal with that, the Law Commission, in fact, has also gone down this route, although it hasn't taken a final view on it yet, to introduce a third concept. Not only intention or demonstration of hostility, but also that someone committed a crime by reason of the identity of the protected person is a concept to be considered. It already exists in the law in a number of European countries and in a number of states in the United States. The Law Commission has said that in essence, it sees the advantage of it in principle, and there have been some concerns raised as to whether it would broaden the scope of hate crime too much. I don't think it would. I think it would only affect a relatively small number of cases, and it would certainly open the door to consideration of introducing gender, for example, and age as protected characteristics, because it makes a more elastic entrance into the world of hate crime for those groups. And as I've indicated, for example, in the instance of age, if you select someone by reason of their age, then not because there's any intent shown or there's any overt demonstration of dislike or hatred or antipathy, then it makes it easier and more effective as a third way of dealing with hate crime. Sorry if that's a wee bit disjointed, but I hope you got the gist of it.
You did indeed. Thank you very much. No, it was a good answer. One I was hoping for.
You've just failed the test.
Rach, that's what you define as a good answer if somebody agrees with you.
I didn't say what my perception was. In terms of the hate expression, and this is a recommendation that you've made about the statutory duty being placed on relevant public authorities to take all reasonable steps to remove hate expression from property where appropriate in the broader public space. And I'm just wondering if you looked at any examples of this from elsewhere and if it had found any best practice from any other jurisdictions, or are we just operating from a very low base here in Northern Ireland because we already have certain duties in place that are perhaps not being fulfilled?
Well, it's funny you should say that. I actually did look to see if I could find any examples from other countries, and I couldn't. It seems to be a particularly unusual Northern Irish problem, unfortunately. And you'll note that in my proposals they're tentatively worded that there should be a statutory duty to take reasonable steps. I understand the difficulties that councils and the Department of Infrastructure, the Housing Executive and the police have, because sometimes they're damned if they do and they're damned if they don't. They can't win. They're going to offend someone. And yet I do think it is important, especially after a new decade, new approach, that I'll give you a simple example. If you we had a witness before the review who came forward, a lovely lady from a Muslim background, and she very gently described this. She said when they moved into a particular street, someone put up a Union flag outside their house. Under no other house, just her house. And it wasn't the 12th of July, it wasn't that time of year. And she said the message to us was, get out, you're not welcome. Now, the Union flag is something many people take great pride in, and justifiably so. But the point is, there was the Union flag being used, or abused, I would say, in a despicable way, to try and send a message, a hateful message, to that Muslim lady. That's just one example. I mean, there are many examples you could choose from, sadly, from both sides of the community. And all I'm suggesting is that when we have that kind of hate expression, the burning of other people's symbols, flags, election posters, whatever it happens to be, when that happens, there should be a statutory duty on these authorities to take reasonable steps. And reasonable steps is where I suppose we get back to the FICT report. It would be helpful, be fascinating in fact to see what 4 years of research that they have done into this has actually produced.
I totally agree with you. I mean, well, it would be good for everybody to see a FICT report. So whoever has it, if they could publish it, that would be nice. I would certainly welcome it. And absolutely, I have many examples in my own constituency of certain activities that have gone on or actions that have been taken, and people have felt deliberately targeted, and we can't find any other reason about why that would have happened. And I know certainly in the council in Ards and North Down, they've been very good at acting against, so say any racist kind of graffiti went up in public spaces. Very, very difficult then whenever it's privately owned, but it's on a public space. So no, certainly I don't think this will be the end of this discussion on public property and hate expression. I had comment, obviously, just like Linda had on restorative justice, and obviously there had been recommendations made within A9 and tackling paramilitarism, and I'm concerned that these are going to be kicked down the line again and ignored by the executive office on the funding, and also on the Centre of Restorative Excellence, which is still it's recommendation A9, and I'm glad to see restorative justice and restorative practice been considered as part of the hate crime review. But finally for me, because I have a list of questions, I could be here all day, but on supporting victims, you had recommended that the PSNI and Department of Justice funded hate crime advocacy service should be placed on a statutory footing. and I would tend to agree with you on that one. But if it wasn't, do you think that it wouldn't be as effective as it needs to be, or what do you think the consequences of it not being on a statutory footing would be?
Well, that's one. The department, generally speaking, have either agreed with my proposals, or they have agreed in principle, or they want further consideration. But the one they haven't agreed with, and they've said should not be going forward, is the notion of putting the Hate Crime Advocacy Service on a statutory footing. They said that that can be dealt with within the department. Now, I don't mind on which footing it is. Well, it's not for me to mind, but what's important is, at the moment, this very, very important organisation, which provides great comfort to victims, is living on a shoestring. Sometimes their budgets are 6 months. I know this is a recurring problem for government, and the department, to be fair, have said that between themselves and the police service, who pay for this very important service, they're hoping to create a 5-year contract, and to make it much and to establish it much more in the mainstream of public services, and to make sure that, for example, there's a proper career path for the mainly young people who join the service from various backgrounds. And as long as that was, I suppose nothing is written in stone. My main reason for hoping it would be a statutory service was to ensure continuity, to ensure that it would survive a sort of political change or a reduction of budgets, either within the police or within the Department of Justice. That's the main reason I was suggesting, and still suggest, that it should be considered as a statutory service. In the various meetings we had all around the country, all over Northern Ireland, between March and January 2020, there was a consistent theme among victims that without the Hate Crime Advocacy Service, they wouldn't have had the courage to come forward. They're a vital link between the citizen and the police, and whether it's done on a statutory service or whether the department can satisfy you as a committee that they will honour their proposal to have a long-term funding for these groups, I don't mind, but it's something that you should explore, and with all due respect, I feel you should explore with them. My own view is it should be a statutory service because it's so important.
Thank you, Judge Martin. Don't worry, I will attend to. Thank you, Chair.
Nice to talk to you.
Thank you, Rachel. Robin.
Thank you, Chair. Can I thank Judge Marion and Mr. Marsden for coming today. My query has already been answered. My 2 queries are going to be answered by the previous 2 speakers. Just very quickly around the age one then. The survey on age under paragraphs 69, 70 and 71, there seems to have been a great disparity on whether age was a factor to be taken into consideration. And you've made the comment about including an agreed age, where you seem to think that there might be some need for intense discussion on that. So it's just that one point, Chair.
Well, good afternoon. I'm not entirely sure. I'm on the same wavelength as you. What I can tell you is that my proposal is that there should, even though what essentially I'm trying to deal with here is older age, I think it should be described as a range of ages, because there could be cases where people are hateful actions are taken against people because they're young, not as likely as older people. In Florida, you might be amused or interested to know that they have a similar protection for age, but for them, elder age begins at 65, which I think is a bit young, personally, myself. But I think rather than trying to find a particular age, I think it should be described, as they do in Scotland. They define age there, which is now protected fully under Scots hate crime law in their recent act. They define age as a range of ages, so as to leave the matter open, whilst the intention is still to help older people, in effect.
Yeah. And the age may be, health may be a determining factor in a person's aging process as opposed to their birth age.
Yes. Yes, you're quite right. A lot of older people, of course, also suffer from a range of illnesses which thankfully don't affect younger people. And it's that vulnerability that certainly the Commissioner for Older People was telling me, who made a very thoughtful contribution. It doesn't cause people to hate older people, but it certainly causes certain criminals to see them as easy pickings, if you like, and it only adds to the distress of older people, many of whom, pandemic or no pandemic, feel threatened in their own homes and don't go out very much. And I think, therefore, this is a golden opportunity to give them some psychological, if you like, protection, that the law will come down harder on people who target older people than they will on the general population.
Yeah, a major part of my constituency is inner city, and a crime against one older person can have a major ripple effect, a tsunami effect, across other older persons in the community.
Absolutely. Absolutely.
Yeah, so thank you, Chair. Thank you.
Thank you.
And I just want to check, Linda, have you another question?
Thank you, Chair. Just very quick, I actually had a few, but thankfully Rachel covered them, particularly in relation just to the statutory basis on the advocacy. And just to say that I absolutely support what Judge Marnon's saying in relation to how vital that is, because if we're accepting that people are targeted because of their vulnerability, then we're saying they're vulnerable. And if they're vulnerable, they need support to go through the process. I just think that's a given. I don't think there should be any quibbling about it. But if I could just very quickly ask Judge Marnon how broad or narrow that he thinks a sectarianism definition should or could be.
How broad or narrow? Well, it shouldn't, for example, include political opinion, because in my view that would offend against freedom of expression. It should include, sadly, people of a Roman Catholic or perceived Roman Catholic, Protestant, perceived Protestant. It should include people perceived to have their cultural identity as British or Irish. The traditional markers that we all know exist in Northern Ireland, but sometimes there are people who, or people who are perceived to come from a particular tradition. I gave the example, for example, of a Protestant Irish speaker. As someone who might be perceived, once they open their mouth, to be of a certain background, but in fact is something quite different. And therefore, I think it should be broad. I think Professor Morrow has, even though the definition he uses looks a bit complicated to begin with, I think it is a sound basis for, at last, after 100 years, addressing this and putting it into legislation that hopefully works for a lot of people who are treated very badly in that respect.
Thank you again, Judge Marnon, for presenting to us, and thank you, Chair. That's me.
Thank you. Thank you, members. I don't think there's nobody else has indicated. But I think that has given us an opportunity to get a sense of, I think the Department's response gives us some sense of a direction of travel. And obviously, as a committee, we'll decide as to how we will take this forward. I notice that a dedicated hate crime branch has now been set up to progress the work and consideration on a multi-agency hate crime review steering reference group. No doubt the Department will have all these various mechanisms put in place, and it'll be our job to try and keep a focus on them. But in the meantime, can I thank you both Judge Marron and also Mr Marsden for coming, and I wish you well on your further appointment, and hopefully we look forward to engaging with you in relation to that. But thank you, and we will decide as to where we go with this, but ultimately it will come at some stage, I suspect, that the Minister or the Department or both will bring forward proposals for legislation. Yes. But it won't be in this mandate, because I think we'll struggle to get what we already have through in this mandate. But can I thank you for the time that you've given, the expertise that you've shared with us today, and your own personal comments, which are invaluable in giving us an insight into this particular issue. And thank you both for being with us today.
Well, thank you for asking me, and if I can provide you with any other help in the future, I'm very happy to do so.
Thank you very much for that offer. Thank you.
Right.
Members, just in terms of maybe just to pick out one of those things, maybe and I see Rachel smiling. She says, are you only going to pick out one of those things? But as obviously it's indicated in this that there's a dedicated hate crime branch has now been set up. What I think we should do is we should ask to get them to come and to brief the committee at some stage. I think that would be useful. But on the advocacy piece, we should write back to the department and ask them for now obviously they've been dismissive up until now in relation to that, about putting it on a statutory basis. But we should probe that one a bit further in terms of giving us some more advice. And if there's any other suggestions that members have as to how we... Rachel, first up.
Thanks, Chair. Just on that piece in terms of if it would need to be made statutory or so on, even if funding was ring-fenced, I know they're looking at a long-term sort of multi-year, annual year budget for the hate crime advocacy service, but if it's not ring-fenced, it can then be, eaten into, so it sort of defeats the purpose of having the multi-year budgets there, or on a continuous basis, so they could be reduced. So that would be certainly something, and I'm gonna pick it up, as I always do, just in terms of the Executive Office on where is recommendation A9 at in terms of the Tackling Paramilitarism programme, and that's the Restorative Justice piece and the Centre of Restorative Excellence, which would be coming through Department of Justice.
Yeah. Okay. Linda?
I support the things that Rachel has just said, and then just if we can ask the department to confirm the impact of waiting on the recommendations in fact might have on including the sectarianism piece in this legislation. I really would be concerned around that.
Okay. Thank you. And who else raised their hand? No, there's nobody else. I don't think. No. Okay, I think I've covered everybody. Thank you. Yep. Just checking, Rachel, have you another query or no, just your hand still up?
Sorry, I have loads of queries, but I'll not. No.
That's okay. Thank you. Okay, thanks for your help in relation to that, members. And obviously, given there's a long journey to go on this one, so we're at the start of this in many respects, and it might also be helpful. We have got there has been changes made to the Scottish legislation, and we might maybe even get an update in regards to that, because all that they proposed ultimately wasn't put in the final, and I noticed that the Minister is proposing some additional changes, so we'll keep an eye on that jurisdiction as well. That brings us then to item 5, the proposals for the development of a joint secure care and justice campus for children at Woodlands-Lakewood site. And the Department of Justice response to the NIAO Report on managing children who offend and other justice issues relevant to children and young people, and that is the oral evidence session with the Northern Ireland Children's Commissioner for Children and Young People. So we're just going to welcome the Commissioner to the meeting. You're very welcome.
Thank you very much, Chair.
Good to see you.
Lovely to be here. I can't tell you how great it is to be here.
Okay, thank you. Well, listen, we'll not... just to remind members that the relevant papers for this particular session are at pages 158 to 523, so there's plenty of material that you've had to be able to read, and just want to welcome you both to the committee today, and we'll ask the Commissioner just to make introductory remarks. I'll get that right yet. And then members will have an opportunity to ask questions. Thank you.
Thank you very much, Chair, and thank you for inviting us to give evidence in person. I really welcome the opportunity to be here with the committee, and to note that this is my first time as Children's Commissioner that I've given evidence to the Justice Committee, certainly not my first time giving evidence to this committee, so I'm very, very pleased to be here. And another highlight is that this is my first evidence session since in the last 18 months to a committee where I've been wearing appropriate footwear rather than my slippers. So again, very, very pleased to be here.
You're not silhouetted by an attic.
I've never done it in my pyjamas, but definitely always in my slippers. I also want to send apologies from our Chief Executive, Mairead McCafferty, who was due to be with us but was called away at the last minute, and I'm joined by Fiona Cole, our Research and Policy worker. So, as you know, it's Nikki's role to ensure the implementation of children's rights in Northern Ireland for every single child. And children's rights apply to each and every child, regardless of their circumstances or their behaviour. They are not transactional, nor do they come with responsibilities. That said, if we are to fulfil the best interests of the child, as the UNCRC and the Justice Order 2002 requires the youth justice system to do, then we must support children to understand the impact of their behaviour on themselves, family, community, and of course victims. That is what makes our communities safer and gives our children the best start in life. So I'm just going to quickly trot through some of the main issues. So firstly, to custody and the work that's being progressed by the Departments of Justice and Health to reform the regional facilities for children and young people, and their proposal to bring secure care and custody into a shared facility. Nikki and our team have engaged extensively with departments on these proposals, and for the record, I am broadly supportive of the direction of travel. But let's not be under any illusion that bringing the two facilities under one roof will resolve what really ails our youth custody system, because it won't. Inspections of Woodlands are favourable. What happens inside Woodlands is not bad, is actually quite good. The issue is whether it and Lakewood are being used properly. It is accepted that depriving a child of their liberty must be a very last resort and should only apply where significant risk is posed and for the shortest time. Last year in Northern Ireland, only 7% of young people in the JJC were sentenced, with the remaining 93% there either on PACE or remand, therefore not convicted of a crime. This is additionally compounded by the fact that nearly 40% of the young people in the JJC were looked after children, those cared for by the state. Therefore, how and where children are looked after if they can't be at home is where the heavy lifting needs to be undertaken. The Criminal Justice Review of 21 years ago was the first of many reviews and processes which have recommended sustainable alternatives to remanding children in custody, highlighting the need for a range of specialist and differentiated services for children in state care and others. It is welcome that the shared campus development proposals have identified the need for satellite and step-down provision, but the lack of detail and plans is frustrating and disappointing, and if not forthcoming, may thwart some of the purpose of the new campus. I'm also really disappointed that the long overdue legislation to reform bail for children is not being progressed, again putting more pressure on the success of the campus initiative. Moving on to outcomes. In 2017, the Northern Ireland Audit Office, as you know, in its Managing Children Who Offend report, examined the cost of youth justice alongside the strategies and interventions used to address offending by children. They found that the Youth Justice Agency could not assess their cost effectiveness and cannot currently demonstrate that the interventions to reduce offending by children represent value for money. The update report published last year outlined that some progress has been made, but again recommends a development of its performance reporting with greater focus on the impact of their work in line with outcomes-based accountability. It's not straightforward to ask an agency to demonstrate impact and effectiveness when success in relation to reducing offending can be complex and multi-agency. However, addressing distance travelled for young people across a range of areas of their lives, such as education, mental health, drug and alcohol use, and stability, is possible. And it's important that every agency, including the Youth Justice Agency, is able to answer the necessary questions of how much did we do, how well did we do it, and is anyone better off as a result? Anecdotal evidence, and I've heard much of it firsthand myself, suggests the Youth Justice Agency endeavours to work effectively. However, there is no robust, published, quantitative or qualitative data to support this view. Moving on to what the system should do. Firstly, we should see the youth justice system as part of the broader children's system, working in partnership with education, youth work and childcare and others to achieve the best outcomes for children. The Children's Service Cooperation Act and its Children and Young People Strategy provides the framework to do that. And Peter Weir will be very familiar with both. It supports agencies to work collaboratively in the overlap areas, which includes early intervention and diversion. In addition to avoiding stigmatisation, diversion from the criminal justice system has good results for children, is in the best interest of public safety and has proven to be cost effective, according to the Committee on the Rights of the Child. It is therefore a mistake that the Youth Justice Agency's Transitioning Youth Justice Framework outlines their intention to develop and grow their work in earlier stage intervention. Diversion from the system should be the first outcome for a young person in the earliest stages of their offending, and diversion from the criminal justice system includes the Youth Justice Agency. Adverse childhood experiences, or ACEs, are a recognised set of circumstances that for some children, if not addressed, will result in difficulties which include educational underachievement, mental health issues, drug and alcohol use and/or criminal behaviour. It is impossible to predict which child will get involved with which behaviours, and many get involved with multiple worrying behaviours. Therefore, broad interventions and early intervention services for children and their families are critical and should be run by those best placed to work with them, which are childcare and education agencies in partnership with the voluntary and community sector. One of the biggest issues concerning our criminal justice system is delay. And there has to be activities with the aim of diverting children from judicial proceedings and consequently of reducing delay by having less children attending court. Delay, as you know, was the issue that most concerned the Youth Justice Review, describing the extent of delay in Northern Ireland as unconscionable. They made a clear recommendation that statutory time limits should be introduced for all youth cases, providing a maximum period from arrest to disposal of 120 days. And they said that should be done at the next available opportunity. There's been quite a few opportunities in the last 9.5 years, and today we see little sustained improvement for children on summons cases when they have to wait a median time of 242 days, and for those who have been charged, 117 days. So the summons children are waiting. That figure of 120 has been busted out of existence. Just very quickly, I want to talk about two other issues that some consider controversial, but we would consider imperative if we are to be serious about putting children's rights and their well-being at the centre of everything we do. At the age of 10, Northern Ireland has an unacceptably low age of criminal responsibility, one that ignores the scientific evidence concerning child, specifically their brain development, and with regards to a child's development and ability to be held legally accountable for their actions. The UN Committee on the Rights of the Child has consistently raised this issue, the issue of age of criminal responsibility, across the UK. And again, I was optimistic that the return of devolution in January 2020 provided an opportunity for proper and informed discussions in our Assembly and to address proposals to implement the recommendation of the Youth Justice Review that the minimum age of criminal responsibility should be increased. And my final issue, equal protection for children from violence in the home. The law regarding physical punishment or smacking of children in Northern Ireland was reformed in 2006 to restrict the defence to assault of reasonable punishment of children. It is notable that legal reform has now been secured in the Republic of Ireland, in Wales, in Scotland and in Jersey. The evidence base is now irrefutable and it's well established and shows that the use of physical punishment is not effective in achieving parenting goals, is detrimental to children's health and development, including having associations with increased childhood aggression, antisocial behaviour and mental health problems, and carries a serious risk of escalation into serious abuse and maltreatment. It is long time past for the Northern Ireland Government to both reform the law to ensure that children in Northern Ireland have equal protection to adults in the home, and to better support parents and families with high quality, positive parenting information and support. when the evidence is so compelling that it is in the best interest of our children to remove a defence to assault, no other argument to the contrary can be considered, nor is it viable. So thank you for listening, and I look forward to your questions.
Thank you, Commissioner. Obviously, the two last issues that you raised are outside the scope in terms of dealing with the issue, particularly in relation to Woodlands. So those are issues that no doubt that this committee will return to at different times, depending on what decision the department takes, if they take any, in relation to changing the legislation as it currently stands. But particularly in relation to the issue of Woodlands, you've said, if I picked you up correctly, that you're in favour generally of where this is going. Do you see, because obviously we've had some correspondence and we've had some issues raised with the committee, particularly around the differential between PACE and Article 44, and how that interface and how that will operate in terms of one co-location or one location in relation to this provision. Have you any view on that particular issue? Because I think that is one of the things that seems to keep reoccurring. And again, can I just say, this is your first time at the committee. This is my third, I think, committee to chair. So I'm new at this. So yes, so I'm treading carefully to try to get my head around many of these things. But would you want to comment on that? Because there is an issue there that I think we need to understand in a very practical way as to how this will operate.
Yeah. So essentially you're saying children who are there in secure care, who are there for reasons of for care, and children who are there for reasons of their criminal activity. And is it okay to bring them together under the same roof? And I suppose on a broader level, I think it probably is. And would say it was, because some of the issues are very similar. Now, the way I understand the campus will be arranged is that children's needs coming in, whether they come in through the Article 44 route or whether they're coming through the criminal justice route, that they will have their needs assessed, and whatever their most paramount sets of needs are, they will go into the bit of Woodlands, and it's organised that you can differentiate in that way, the bit of Woodlands that best meets their needs. So from mixing the two types of kids, young people, I'm not anxious necessarily, and we need to see how it will done. What I will say, Chair, is that when Fiona and I met with some young people who had previous experience, they were a bit anxious, and I was quite taken aback by that. So there is a job of work to do with the young people. Once the plans have been as part of the process of developing the plans of how this is done, I think we need to ensure that we include the voices and experiences of young people in those planning processes. So in theory, no, I don't have an objection. I am very supportive that the new centre will be based on the needs of the child, and we see children with similar needs in both Woodlands and Lakewood. But I think as we move forward, the young people need to be central to how that actually rolls out, because they are a little bit nervous about it, certainly the ones we spoke with.
Thank you.
It's a very long-winded answer to your question.
No, that's fine. No, thank you. I want to give members as much time as this, so I want to go to Rachel first.
Thank you, Chair. You regret saying that. I have loads of questions, as usual. Thank you, Kula. Hi, Kula, and hi, Fiona. Thank you very much for coming to speak to us today. I know it's been a long time coming. It's been on our agenda for some time to get you in. And thank you for your opening remarks, and the briefing paper that you supplied to us was very useful. I have a number of things just on the proposals that we're specifically talking about in new regional facilities, and then a number of other questions just on other youth justice matters, if that's okay. So I'll start with the regional facilities. And you had stated that there remains some work to be done, and I would agree with you, and I think others working in children's rights and representing children's voices in this would also agree, and the committee informally met some of them on Monday, and I know, Chair, we have a list of things to follow up with the department on. In terms of the phased basis that the department seemed to be going with introducing this new regional care facility, I'm not too sure if that's going to be the best way given the unknowns, but some have expressed that the department, because it's joint with Justice and Health, might also be missing a trick, and that actually there's we could do some better things with this, and this could be good. So I'm just wondering if you have any opinion on if there's anything here that the departments are missing a trick on.
So I suppose that what the departments have chosen to do is I don't want this to sound the way it sounds, but to do the easy things first, and look at the service being provided for those young people. The issue, and I'm old enough to remember when the Juvenile Justice Centre was built, the issue was was then and is now that we lock up too many children. And when designing a service that's custodial for custody, we're looking at the current provision and we're investing that money in the current numbers. But actually, if we're serious about reducing the numbers, that's what we should be looking at, so that we invest less money in custody and more money in custody and secure care, more money in the community. So I understand why they have gone with the centre first, but actually they are investing in something that that if it works out, that they should make smaller and smaller. But we're not seeing the plans of how they're going to make it smaller and smaller, and how less and less children are going to go into custody. So from that point of view, it's not the most efficient way of doing it, but it's definitely the easiest way of doing it, because they're resolving the easy issue rather than the issue that we have all been struggling with for 25 years. So it's not that they're missing a trick, it's just they've chosen to go with the tricks that are easier to perform. Thank you, Kira. Appreciate your answer. And in relation to this, certainly with the facilities, it's my understanding that in a previous version of the Justice Bill that had been drafted, there were provisions relating to the reform of bail conditions for children and young people, and I believe that it was to strengthen the existing automatic presumption of bail for children and introduce specific conditions which must be met before a child can be remanded in custody and others in order to comply with UNCRC responsibilities. Would you have any information, or could you outline what impact not legislating on this now would have for children and young people? What your position would be that without this, and would this have any effect on the new regional facilities, in your opinion? So both bail, remand and PACE are the two areas that have to be reformed. So the fact that we're not reforming bail to make it easier for children to get bail in the community, to withdraw some of the conditions, such as the absence of accommodation being a reason to remand into custody, will have meant that less children will be in custody for reasons they shouldn't be there. We should only have children in custody who pose a serious risk to their community, and there is no way that today, say there's 20 children in custody, there is no way we have 20 children in Northern Ireland who pose a serious risk to their community, particularly when we know that last year 97 of them were bail and remanded. So if we make bail harder, if we put in the measures in place to ensure that only children are denied bail who pose the most serious risk to their community, then we will have less children in custody. And it is an absolute violation of children's rights to lock up children because there is insufficient services in their communities to provide a roof over their head, for example. So I'm glad you didn't ask me this question a week ago, because I think I would have burst into tears at the fact that we're not progressing with bail reform, because this is another one that's been on the agenda for over 15 years and we should have progressed it 15 years ago, and actually it was recommended in the Criminal Justice Review of 21 years ago. And we have had 5 or 6 generations of children through the system who have had their rights violated and have been locked up needlessly because of outdated bail laws and insufficient services in the community. So,
Thank you.
Not much opinion on that, Rachel?
No, not at all. I don't think you could be any clearer. I think it's a damning indictment on any of us why this is not being progressed. I have absolutely no idea why, and certainly will continue to ask those questions. And I don't think you could have put it any clearer to the committee or indeed the Assembly. I want to touch upon 2 things that is in your briefing. One is minimum age. You will know my position on that and the absolute need for legislation on this. The Assembly must legislate on this. There is no ifs and buts on this. It has to happen. And I would like to know, just from your perspective and from the children and young people that you and your office have worked with, how important is it that Northern Ireland legislates on the minimum age of criminal responsibility to be increased, and the future of youth justice and how we deal with many of the issues that young people are facing?
So just to be clear, raising the age of minimum age of criminal responsibility, raising the minimum age of criminal responsibility does not mean letting children off with it. I have quotation marks. What it means is that we find a different way of supporting children to understand what they've done. And based on what I've said about adverse childhood experiences, we know that many children find themselves embroiled and involved in offending as a result of consequences and things going on at home and in their communities. Therefore, if we remove, bearing in mind what I've said about how long it sometimes takes to resolve cases, if we remove the criminal justice system from this equation, we are more likely to be able to intervene earlier and more effectively with these children and young people, thereby supporting them to reduce that sort of criminalised behaviour. I think it's long overdue. The Youth Justice Review in 2009 said it should be raised to 2011. Said it should be raised to 12, and then within 3 years it should be raised to 14. So that meant by 2014 we should have had an age of 14. Here we sit in 2021 when we're still at 10. And also to be clear for anyone who is doubting what I'm saying, if a child poses a significant risk, if a child under 14, similarly as a child under 10 today, if they pose a significant risk to themselves or their community, we have secure care available for those purposes. So I'm not for 1 minute saying children who may be considered dangerous, bearing in mind there's very few of them. But the minimum age of criminal responsibility actually, I think, ties the hands of many to intervene early and effectively with young people involved with behaviours that may be considered criminal or antisocial.
Thank you, Commissioner. And finally, for me, just on equal protection, I agree it's long past time that children should have equal protection. I see no reason why this wouldn't be legislated for as soon as it's practical, and I think we've had a number of missed opportunities, like a lot of things on that. And again, I'm disappointed that it's unlikely to happen within this Assembly mandate. And I know certainly there had been discussions through the domestic abuse bill, and also there was a lot of hopes for further bills, but we are where we are with the mandates and the times. But there's always next mandate. So just wondering, in terms of what you see in Scotland, Wales, Republic of Ireland and Jersey, it's even noted that in your briefing, the children and young people there do have equal protection, and obviously there are commissioners throughout the UK. It's been any conversation about what the hold-up is here for children and young people, what the difference is?
I have no idea what the hold-up is here. I suppose, what the hold-up is here, I'm not going to comment on because I don't want to get political. I suppose what I want to see is the Assembly, this place, having that debate. I think it would be, I don't for 1 minute think that all 90 MLAs agree with us that children should be supported in this way. I think probably the majority do, but I would very much look forward to having a proper debate and discussion and informing the process going forward. I think this Assembly is perfectly capable of making those decisions. So it would be, I know there's another mandate, but Rachel, I only have 20 months left in this job. And it was one of my to-do lists when I became Children's Commissioner. And it may be, and I would be devastated whilst I watch children on these islands, and it looks like England are getting closer. If I leave this job and every other child in the UK and Ireland is protected and our children are not, that will be a source of deep, deep disappointment and shame for us and for me personally.
Thank you, Commissioner. Chair, I'll leave that there because I could hog the whole time with this.
Thank you.
Thank you.
Thank you. Linda.
Thank you, Chair. And Rachel has covered some of the points, but just to quickly go back to one of the last points that the Coola made around, you know, the fact that there is secure care for a child under 10, and that would similarly remain if the age of criminal responsibility was raised, which I absolutely think it should be. I think that we all need to ask ourselves why any child is a serious danger to themselves or others around them, and what we are not doing or where we failed them. So that needs to be our starting point when we're talking about these children, not, you know, how bad is a child and we need to make sure that they're kept away from the community. It's what have we done to those children or not done for them, that's the position that they're in. So I absolutely support your call, and I do think that it's really sad that we're not in a position that the department did intend to try to bring that forward as an amendment to the Justice Bill, and we're now not in a position to be able to do that. And I agree with you in relation to we have another mandate, but that's just further delays for these kids, and it has an impact on the children who are out there now, who need our support, who need to get the proper interventions. So just to go back to Coola, to the new facility, and one of the issues that was raised with us by the groups that we met on the informal session is around, and you've raised it yourself, is around the satellite services. And the concern around the satellite services is, whilst it sounds like a great idea, and it does, and it's what we all want to hear, it's what we want to deliver, but as they have said, it's just like a directory. There's nothing there, and as you said yourself around the detail, there's nothing there to say that these young people will actually be able to access the services. There's just a list of services that are available. What does that tell us? There's no plan in place for these children. There's no plan in place for how the satellite services are going to deliver. And the other concern they had was that it was all statutory on this directory. The community and voluntary don't appear to be anywhere on it. And we all know that the community and voluntary sector, in terms of support for anybody in our community, are worth their weight in gold. And we get, to bring it back to what is important to so many people out there, you get far more bang for your buck.
Yeah.
Not true. You know, and that is the truth of it. Like, we get far more out of community and voluntary sector. And that's not taken away from the statutory. We need the mix of both. But we do. And so those are issues, Chair, that I think we need to specifically ask the department about. We need some answers around those issues. I don't know if Coola wants to comment on it, because I mean you're, I think, pretty much on the same page, but if you just want to comment on what your view of that is.
Yeah, just to say that, like I said earlier, we know particularly in Woodlands that children are there for the lack of services, not because of their behaviour. I am frustrated. I've been working in youth justice in Northern Ireland since 1998, and I wish I could say this is the first time we've had this conversation. It's not. I mean, I look at the clerk, and her and I in this committee have had these conversations. So it's deeply frustrating that we have yet to have a proper comprehensive community-based services, as you say, a blend of statutory and voluntary and community that are able to keep young people out of custody. And to make that happen, we need to close the door to the Juvenile Justice Centre as a place of safety for PACE, for overnight remands, and make conditions for bail, remand into custody much tougher. Because until we close the door and don't allow those kids to go into custody, we will not be able to focus the mind of those who run our community-based services. We tried the softly, wouldn't it be a good idea? It doesn't work. It hasn't worked in my experience over the last, I can't believe I'm going to say this, 23 years. So we need the legislation to close those doors, and we need to get on with it and develop those services for those young people.
If I can...
I think you're right. Related to...
Yep, Fiona wants to come in there.
Go ahead, Fiona.
Just a small addition, Linda, and thank you for raising this important question. Something we have been in discussions with the department about is a simple mapping exercise that includes community voluntary sector, that goes beyond the justice remit, but health, education, and community. Something that we are seeing is that the statistics west of the ban or further distance travelled to the likes of Woodlands, you're seeing significant numbers that have community provision. We're asking the simple question, why is that? Is it distance travelled to the JGC, or is there provision in the area? We're also seeing some fantastic models in the community that's looking at this, both here in the north, but also across in Scotland. We need to see that evidence-based, and we need to see it demonstrated in a consultation that the community voluntary sector can be included in those solutions. But a simple mapping exercise of why do we not have places of safety, what is required for places of safety, what would that mean in terms of resource, but actually also who would look at it. It should be a social care issue, not a justice issue. But if we have that conversation across using the Children's Services Cooperation Act, it will put the success of this joint campus in a much better and safer footing.
Thank you, Fiona. Appreciate that, and I definitely think we'll want to have more conversations and get more detail around, particularly around those models. I certainly would like to have more conversations with you around those. Kula, I mean, you've talked about focusing the mind, and I think you're right. I think that unless you don't have that option, then you won't be focused and to find what the other options are. I think I know your answer to this, but the issue around the statutory time limits on YGR of the 120 days, I mean, the department have pushed back on that, and statutory time limits are only, I suppose, as good as if you meet them. And I think that probably the department's concern is that they will continuously surpass the statutory time limits, and that may well happen. But in my view, if you put them in place, you at least put targets. And again, it's about focusing minds. Do you think that there is value in them, or are they of limited value if there's no penalties for surpassing?
Well, I think that's the point. I think that, you know, the 120, like I said, was a 2011 recommendation. We have worked with the Department of Justice to try and come up with ways of reducing it. That they've talked about administrative time limits. They've talked about different projects and different services and different initiatives like early plea, all sorts of things. And yet in children's cases, we are, as we say, for Summers cases at 242 days, we've not seen a significant improvement. I don't understand why now we cannot say, right, put in a statutory time limit of 120 days, hold those services, so we're talking PSNI, courts, PPS, and probably the agency, hold them to account to work better together, to meet those, and understand why if they breach the 120 days, why they have done that. So 9.5 years we've been at this, and we're not seeing any improvement on children's cases. We're seeing improvements on adult cases, but we're not seeing improvements on children's cases. Surely now is the time to introduce a statutory time limit. And we have seen improvements across the water when they have done this, and I don't understand why there is still a reluctance to do it when they have been given nearly a decade to improve their processes and systems and have continued to fail to do so. So yeah, it's the only thing we've got left, Linda.
I think you're right. I think that if if everybody is going to be held to account on whose part has fallen down and allowed them to go over the time limits, then everyone will feel a wee bit more of a sense of responsibility. And as you say, it'll be in their interest to work together. I do think that that's vital. Just a last point, Chair. Obviously, there are concerns, and this has been raised before, around the number of occasions that young people from Catholic backgrounds, they're 3 times more likely to be detained in custody. And I mean, I accept that there are a multitude of reasons for this, but I don't see any plan in place to establish what are those reasons and how do we tackle them. And that really concerns me. And I mean, you've talked before about, and Fiona just mentioned, that no solution is just a justice one. I accept that this is much wider than justice, but it needs to start somewhere. And the fact is that they're ending up going through the court system, they're ending up going through the legal system. So justice has to look at why is that. And if there are other departments that need to take responsibility, then that's okay. But at least you'll have the evidence there to say that.
Just to say, it is an extraordinary figure. The disproportionate number of children who identify as Catholic in the Juvenile Justice Centre has been ridiculously disproportionate for about 3 or 4 years, if not longer. What I do know is happening is that a piece of work has been commissioned to try and understand what that is. Bear in mind that it's not the Youth Justice Agency's responsibility, because they just receive the children. So there is a piece of work that I hope will report soon that will begin to understand what's happened, why that's happened. Is it bail conditions? Is it policing activity? Is it where they live? What are the reasons? So I'm glad that a piece of work is finally commissioned. I'm frustrated it's been a bit late, but they are extraordinary figures, and ones that we absolutely need to understand and address. So once the work that's been commissioned by the youth justice system has been completed, then we should expect to see an action plan quite soon, is my understanding.
That has been commissioned by the youth justice system.
Yeah, there's a piece of work being commissioned by Queen's. I was interviewed by the researcher. So there's a piece of work being commissioned by Queen's to understand what's going on. And then I hope once that reports that this committee will then, and me as Commissioner, will then see a plan about how, an understanding of how this figure, how it's so extraordinarily disproportionate, and then how they're gonna reduce that.
Thank you. Carla, was Fiona looking to come in there? No.
Yeah. Just a small thing, sorry, apologies. It's just really something we've been working with the PSNI on as well, is usually for a young person, the first contact that they may have is with a PSNI officer, and it can come in the form of stop and search. Now, Section 75 details say that sometimes that those religious backgrounds cannot be ascertained, but what we're trying to work with, and we're doing a significant piece of work, is how that engagement goes, how they actually contact that young person, how do they converse with that young person, and can they meaningfully engage that information, because that needs to be, before, when they come to the Juvenile Justice Centre, that story is too far on. We need to be understanding very early on, not just from a criminal perspective, but from a safeguarding and a well-being perspective, that actually those interventions need to be happening a lot further on. And that's why we're saying that in early intervention, that it shouldn't just be a criminal justice, but it should be a social care issue, and that they do so, but need to work closer with counterparts in those early interventions. So that work with the PSNI is going on, and they are going to be releasing a survey that they've done substantially with over 2,500 young people on their experiences of stop and search in Northern Ireland.
That's really good and very interesting to know, and I could talk about that particular topic all day, so I'm not even going to start, but I just want to thank Commissioner Kula and Fiona for coming to the committee and responding to our concerns today. And Kula, I don't think it'll be as long till you're back in front of the committee again somehow.
Oh, okay. I look forward to it, Linda.
Okay, can I just check if there's no other members have indicated in terms of questions. Can I just conclude by asking, because in terms of, so when we look at this issue in relation to the Woodlands provision and what is in the either residential provision, it's not a case of either or.
No.
It is a combination of both.
So Woodlands is there for a purpose. Woodlands is there because society believes that there are children whose behaviour is so serious that they may need, you know, whose criminal behaviour is so serious that they need security. The problem with Woodlands is that there are too many children whose behaviour is not so serious that they need security, but they don't have somewhere to go, or there isn't provision to meet their needs. So we know there's a disproportionate number of young people in Woodlands who have mental health issues. Yeah. We know there's a disproportionate number of Woodlands who have drug and alcohol issues. I mean, I could talk about the lack of services for children with drug and alcohol issues. So we know that Woodlands is being treated as a children's home.
Yeah.
Now, if it's going to be treated as a children's home, let's raise the age. I keep saying lower. Let's raise the age of criminal responsibility and have a different conversation. So let's not be locking up children because they have adverse childhood experiences, because they have trauma. These children are not committing crimes that warrant me and my children being protected from them or themselves. That is the problem. The problem is we are locking up children for reasons other than their criminal activity. We are locking up children because of, like I said, their adverse childhood experiences, their distress, their trauma, and for want of a bed. That's the problem, Chair. And that's what's frustrating, because what the staff in Woodlands, what happens in Woodlands and also in Lakewood is good. They're getting good services. That's why they're not kicking up a stink about leaving, because the services have been consistently, particularly in Woodlands, consistently inspected, and we're being told how good they are. Children shouldn't be locked up to get good services.
Yeah.
That's the other soul-destroying thing. They deserve that in the community. We have responsibility to them in the community.
And would you then conclude that that is also a reason why, according to the NIAO or the audit report, that repeat offenders account for disproportionately high percentage of all incidents, representing 72% of all youth and crime and disorder? So that takes me to my point about what works for these young people. The Youth Justice Agency is a very skilled criminal justice social work agency. They're very skilled people, and we need them to focus their minds on these young people, the young people who are embedded in criminal activity for whatever reason. Once a young person becomes entrenched in criminal behaviour, it's incredibly, and once they're sucked into this system, once they accept the label that we give them of being criminal, of being this and of being that, and they embrace that label, it is incredibly difficult to get them out of it, but it's not impossible. So yes, bearing in mind how how fewer young people we have in the criminal justice system, the churn in custody, the revolving door in custody and in Lakewood is atrocious, which is one of the reasons they bring the centres together to try and have services in place that will properly address that. But that's what we need the Youth Justice Agency to be doing, Chair. Not earlier intervention, which can be done elsewhere, working with these young people to prevent reoffending. Those young people who are entrenched in this behaviour because of their trauma, because of the other issues. Okay, thank you, Commissioner. There are no other members who've indicated questions. Can I thank you for taking the time, and apologies that it has taken. I'll abdicate myself of any responsibility because I wasn't here. But and also to Fiona for coming, and thank you for your presentation to us today. Thank you very much.
Thank you. Thank you very much, and look forward to seeing you again soon.
Thank you. think the last time we saw each other was probably in Ballymoney.
It was in Ballymoney.
Lady of Lourdes prize giving, I think that's what it was.
Yep. Several of them.
Yep. Thank you. Thank you. Okay, members, we just need to be careful and cautious about one wee issue, and that is quorum. Could I indulge? I think we're okay at the moment, aren't we, Christian? So if everybody can just bear with me, because we have a couple of things that we need to get done before we conclude. So if we stay as we are, we're okay. That brings us then to item 6, which is the Justice on Sexual Offences and Trafficking Victims Bill proposals for committee stage. Pages 525 to 583 of the meeting pack, and also pages 120 to 137 of the table pack are the relevant papers. Obviously, the Minister's introduced the bill on the Assembly on the 5th of July. And just given the time available for the bill to complete its passage through the Assembly before the end of the mandate is very limited, the committee agreed at the meeting last week that it would consider proposals to call for written evidence following the introduction of the bill, rather than waiting until the committee stage has commenced. Proposals have been drawn up and they were circulated to members yesterday afternoon and can also be found at pages 120 to 132 of the table pack. Committee also agreed to request details of the policy to be covered by each of the 4 amendments to the Minister, and the Minister has indicated she is intending to bring forward, including the wording of the amendments, if available, and confirmation of the provisions that have been removed from the original version of the bill. The Department's response is found at pages 133 to 136 of the table pack. And the Department has outlined the areas covered by the provisions that have been removed. It also advised that the preparation of draft instructions for the amendments is underway for intended use of the Office of Legislative Counsel for drafting over the summer, and will share the draft text at the earliest opportunity. Draft media assigned posting notice, a draft letter inviting written evidence, and a list of key stakeholders to which the letter will be sent have been prepared, and it's proposed that the media assigned posting notice will be placed in the papers during the week commencing the 19th of July, and the letters will also issue that week. And the reason for that is because obviously if we do it next week, it's a holiday week. It's better if we leave that week and go for the week commencing the 19th. And the closing date for receipt of written evidence being Friday the 24th of September, by which time the second stage should be completed. A request for the views of the amendments has also been included in the draft letter to key stakeholders. So really it's to seek the agreement of members that the written evidence on the bill should be requested before the committee stage commences, and the media assigned posting notice and the letters to the key stakeholders should issue during the week commencing the 19th of July. Are we agreed with that?
Agreed, Chair.
Okay. Also agreement to the closing date of Friday the 24th of September in receipt of written evidence. Agreed?
Agreed.
And also agreement for members that the views should also be sought on the Minister's proposed amendments when seeking evidence on the bill.
Agreed.
And also that members are content with the draft media sign posting notice, the draft letter and the list of stakeholders. I just want to raise maybe in terms of the stakeholders, notice that there's not much reference to education in the draft, is there? I had it earlier. They're covered. Yeah. Students' Union is included, yes. And the other one that Linda will not be surprised I'll raise, that is obviously there's no reference to the loyal orders under religious organisations with the loyal orders. And also, if you look at religious organisations, while we cover the main churches, the Church of Ireland, the Methodist, the Presbyterian, there's no reference to the smaller evangelical churches, organisations such as the Reformed Presbyterian. There's a list of them that should also be included. and somebody else raised with me. Yes, and in religious organisations, there's no reference to non-Christian religious organisations. So, for example, the Jewish community, the Muslim community, any other minority communities in Northern Ireland in terms of religious organisations. Any other comments in relation to that, members? Okay, happy enough. Thank you. Then that brings us then to item 7, which is the Access NI Annual Performance Activity Report 2020-2021, the publication of the updated statutory guidance for the Chief Officers of Police. You'll find that at pages 585 to 635 of the relevant papers for today. The Department has provided the copy of Access NI Performance and Activity Report, which gives an overview of the service provided to the public. The Department has also provided a copy of updated statutory guidance for Chief Officers of Police issued by Access NI. This guidance is used by police officers when applying the statutory test to information they hold in relation to applicants for enhanced criminal record checks to inform decisions on whether such information should be disclosed in the final certificate issued. In updating the guidance, Access NI has consulted with relevant groups, including the PSNI, and are all content with the updated version. So just to ask the members to note the 2020-2021 Access NI Performance Activity Report and the updated statutory guidance unless there is any further information that we require. Okay, thank you. Item 8, that brings us to correspondence, and there are 4 items of correspondence at pages 637 to 659 and of the meeting pack, and 5 items of correspondence at page 142 to 174 of the table pack. Just draw your attention to 2 of the items in the table pack, and members will then have the opportunity to comment on any other items of correspondence that they feel relevant. And it's item 5 at page 142 to 143 of the table pack, and it's a copy of a response from the Minister of Justice providing an update on Operation Encompass. And I know there's an issue that Linda has raised previously. And obviously the discussions are ongoing to inform the drafting of the regulations for Operation Encompass and determine how the model will work in practice. And the Minister intends to bring the draft regulations forward in early 2022. Separately, work is ongoing to launch a pilot of the model in September in the Down area. So just to note, unless, Linda, do you want to make any comment in relation to that?
I'm assuming that the delay in that, and Peter probably would have been able to answer this one, that the delay in that was COVID, because I know that right back whenever we first started discussing Operation Encompass, which seems that long ago now, I can hardly remember when it was, that they talked about that pilot. So I'm assuming COVID was the delay on that, and I am glad to see the pilot coming forward, and are just really keen to see the regulations put in place. To be honest, I think that this is essential and can really have a big impact on young people, on children, and the outcomes that they might have in terms of their education.
I suppose too, and we can seek clarification on that point as to what was the nature or the reason for the delay. It probably was the COVID issue, but I suppose too the other thing is, and again it may be an operational issue as to why they just picked one area for a pilot. And of course it doesn't matter where you pick for a pilot. Somebody will always say, well, why did you not pick somewhere else? But they've gone just for one specific area in the Down area. But we'll wait to see, and obviously we'll be interested to see what the outcome of that is.
I think to be fair, that education actually took the lead on
Right.
that pilot. In fairness to them, we're ahead of the ball on this one, so it might be worth writing to the Education Minister, to Michelle McAbeen, and asking, how did they pick that area? What was the criteria, the reason? And it may well be something to do with operationally, but it would be interesting to know.
Okay. Yep. Okay. Thank you. No other comments in relation to that. Item 9 at page 174 of the table pack and his correspondence from the Committee for the Economy seeking evidence on the parental bereavement leave and pay bill by the 16th of August. And the bill was introduced, or the bill will introduce regulations creating a legal requirement for all employers to grant a period of a minimum of 2 weeks of parental leave. So it's really to get the agreement of members to request the views and comments from the Department of Justice on the clauses in the bill relevant to its responsibilities and any likely implications, and given the closing date for written evidence for the response to be forwarded to the Committee for the Economy as soon as it is received. The committee can then consider this particular issue at our meeting on the 9th of September. So are we content to action the remaining items of the correspondence as set out in the cover sheets, or whether there's any other comments that anyone else wants to make? Linda?
Just a quick comment. I'm happy to note and action all as is suggested. Just in relation to the parental bereavement, we raised and we've raised consistently around the issue of paid leave for those who are victims of domestic violence, and I think maybe if we can just go back to the department again on that and ask them, are they doing any work on it? You know, have they done anything in relation to this at all? Even in terms of having a conversation with Rachel about her private members bill.
Rachel, do you want to comment?
I can comment. No, there has been no conversation with me in development of the private members bill. But the offer is still there for all political parties to engage, if that helps.
Okay, thank you. Okay, thank you for that, Linda and Rachel. That then brings us to item 9, which is chairperson's business. Just to note that it's normal procedure for the committee to delegate authority to the chairperson and the deputy chairperson to submit during periods of recess views on the releasing or withholding of information in any known, routine or contentious freedom of information request received by the committee. So it's just to seek the agreement of the members to adopt this procedure over the summer recess, and I'm sure the deputy chair will be quite happy to be in that position over the summer months. Agreed?
Agreed.
Linda, have you is there, maybe you just didn't bring your hand down, I just want to make sure, have you another query? No? It was down now.
I didn't.
That's all right.
But just say to the staff, obviously this is our last committee meeting, but our staff will be, as always, busy over the summer months, and I know that their work never stops, and they have arranged some meetings for us over the summer. So just want to put on record our appreciation for all the work that they have done all year, and as I say, it doesn't stop. Assembly might go into recess and no committee meetings, but the work doesn't stop for any of us, but it certainly doesn't stop for our staff. So just to put on record that we appreciate it, and I hope they get some sort of a holiday and a break to just get their head shared, I suppose, like the rest of us. So just to put that on record, Chair, I think.
Yeah, I just want to concur with that, Linda, and I think there is an issue generally in the Assembly in terms of the number of staff who have accumulated flexi time and so on. So there's a huge pressure on the staff here in the Assembly. But the one thing that has really impressed me since coming to this committee is the volume of work that our staff on this committee have to deal with. And I've said it before, said last week, you know, we're dealing with, 700-800 pages of information in our committee packs, and that is a huge amount of material to put together. So I concur with those comments, and I place on record our appreciation to Christian and to her staff for the way that they serve as this committee, and trust that they do get a bit of a break over the summer. That just raises or just brings us to any other items of business, unless there's anything else anybody else wants to raise. And if not, then the date and time of our next meeting, apart from those informal meetings that are being arranged over the summer, is due for Thursday the 9th of September. That's just a few days after my birthday, so you can have the birthday cake on that occasion. And it'll be at 2 p.m. in the Senate chamber here in Parliament Buildings, unless an urgent issue arises that requires the committee to reconvene, in which case the members will be contacted. So can I wish you well over the summer period, and thank you for your help in the meetings that we've already chaired. And there's no doubt we have a huge amount of work ahead of us come September. We'll be busy in the committee and in the chamber, so enjoy your well-earned rest. Thank you very much.
You too, Chair. Thank you.
Thank you.
Is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is